Good morning, ladies and gentlemen. Welcome back. Hopefully you all had a nice evening and ready to continue on and conclude this matter. As you remember, we are in the middle of the state's case in chief. So Ms. Linden, are you prepared to proceed?
I am, Your Honor.
Please call your next witness.
Thank you, Your Honor. State the call Officer Michael Jones to the stand.
Good morning.
Good morning.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat.
Thank you. All right, thanks.
Whenever you're ready, Ms. Linden.
Thank you, Your Honor. Officer Jones, if you could please introduce yourself to the jury and spell your first and last name for the record.
Officer Michael Jones, Willoughby Hills Police Department, Michaeljones.
Where are you employed?
Willoughby Hills Police Department.
What do you do there?
I'm a police officer.
Well, if you could tell us a little bit about how long you've been a police officer and what your training is, please.
I've been at Willoughby Hills for 15 years now. I started in Fairport for about 2.5, 3 years, so almost 18 years on. Accident investigation, traffic enforcement, respond to any calls of service.
You're a certified police officer in the state of Ohio.
I am.
What kind of training did you have to go through to become certified?
Police Academy.
And did you finish the police academy?
I did at Cleveland Heights.
Cleveland Heights. And since that time, you said it was, what, 17 years ago?
Probably 17, 18, somewhere in that ballpark.
Okay. Since that time, have you had any additional training at all?
I've had several different trainings.
Okay. Any training regarding alcohol and drug detection?
ADAP, which was in Police Academy, which was training for that.
And what about in terms of chases or people who are fleeing from the police? Are there any policies through the Willoughby Hills Police Department that you're aware of?
There are.
Okay. And in terms of your position now, do you have any additional, other than being a police officer, are you a training officer? Are you in charge of some of the shifts?
I am an FTO training officer, and usually when the sergeant's not there, it's called an OIC, officer in charge. And
the OIC?
I am. When the sergeant's not there, I am.
Okay. And in your capacity with Fairport Harbor, you're a police officer there as well?
Correct.
I want to direct your attention here back to August 31st of 2025. Do you recall if you were working on that day?
I do.
And where were you working and what were you doing?
City of Willoughby Hills as a police officer. I was also in charge that night.
Okay. How many other people were on your shift with you?
I believe it was just 3 of us total, Officer Meir and Officer McNamara.
And that's for the whole city
For the
of
whole
Willoughby Hills?
for the whole city.
Okay. All right. During the course of your work on that day, well, let me back up a second. What hours would you have worked?
7 p.m. to 7 a.m.
And that was a Sunday?
It was.
In the early morning hours, a little after 2 a.m., do you recall having contact with an individual by the name of Christian McLean?
I do.
How is it that you came to come in contact with Mr. McLean?
Officer Meir conducted a traffic stop. He requested an additional unit. He stated that the vehicle was all over the roadway, possibly impaired. Requested backup. I responded to his location.
Is that pretty typical to request backup in that situation?
Absolutely.
And why is that?
Being on the highway, it's not a one-man job. If you're going to go a little bit further investigating for possible impairment, taking anyone out of a car is just a 2-man job at least.
And so if you're out on the roadway, do you wait for another individual to show up?
Yes.
And on that date, were you in uniform, like similar to what you have on today?
I was.
Okay. And were you in a marked patrol car as well?
I was.
And what kind of patrol vehicle did you have?
Ford Explorer.
And what kind of markings on that vehicle indicate that it's a police car?
Willoughby Hills Police.
Okay.
All over it.
Okay. Any lights or sirens that go along with that?
Both.
Okay. And on On your uniform, do you have any things like flashlights or reporting devices, duty belt?
I have a body camera, duty belt, my vest.
And on your vest, is it clear that you're a police officer?
It is.
And do you have are there any markings on the back of your vest that also indicate you're a police officer?
Big giant police on the back of my vest and a badge that says police and also a small patch.
When you responded to the scene, approximately how long did it take for you to get there once you got that call for backup?
I can't be positive, but within 5 minutes, I would probably say more like 2 to 3.
Okay. When you got there, what did you do?
I initially met with Officer Muir. He said he wanted to investigate or do further testing, do some field sobriety tests to investigate if he was impaired or not. I already noticed that there was it's called a Terminator stop stick that you would put at the rear passenger tire just in case someone did flee the scene. He must have had some type of feeling that put him in that situation where...
Sustain. Ask your next question, please.
Do you use a Terminator stick in all circumstances, any stop?
Not every stop, but it's frequently used, yes.
I'm just showing the posting house again, what was previously marked as the 5A. May I approach?
You may.
Officer Jones, do you recognize what 5A is?
I do.
What is that?
That is what we call the Terminator stop stick.
And that's what you're referring to here, that you noticed that?
Correct.
Okay. And in speaking to Officer Muir, what was the purpose of talking to him about what was going on scene?
He believed that there was impairment with the driver and wanted to take...
Sustain.
In speaking to Officer Muir, did he provide information to you that led you to do what you decided to do next?
Yes.
Okay. What were you going to do based on what Officer Muir said to you?
I was going to have Mr. McLean step out of the vehicle and investigate further.
And this incident that we're talking about in stop of Mr. McLean, this is actually in Willoughby Hills, Lake County, Ohio?
Correct.
Okay. Any other officers on scene at that point in time?
Not at this time.
Tell me what you did then to investigate this further.
Usually the officer that makes the stop will stand back. The assisting officer will go up and have the driver turn off the vehicle, step out, and explain to walk back to him. Just keep your hands out of your pockets. Kind of a basic thing so he can explain further instructions at the back of the car.
Okay, and that's something that legally you're permitted to do, ask somebody to get out of the car.
Correct. Correct.
And so when you went up to the car to talk to Mr. McLean about that, what did you first notice about Mr. McLean and the status of the vehicle?
I mean, the window was, it was rolled up probably that much. It was opened. It was hard to, communicate fully to him. I did tell him to roll it down a few times, but that didn't happen. But
what's the purpose of having them roll the window down?
So we can speak clearly and understand each other, just basic communication. It's kind of hard to understand when the window's cracked that much.
And if the window's up like that, is it harder or easier to see inside the vehicle and see what's going on?
It's harder, especially.
What did you observe about the defendant?
He was, I don't know what word I would use, but just very emotional and kind of just loud. He really wasn't paying attention to me much. I was trying to talk to him, tell him to turn off the car and step out. He said that he wanted to call his mom. His phone was on his lap, and he was just yelling about talking to his mom on the phone. Said he did nothing wrong. At one point, he said we wanted to kill him. I explained to him that that's not the case, and he didn't need to speak to his mother. He needed to speak to me at that time.
And was he speaking to you at all?
No, he was more focused on talking to Mom at that time, which the phone, like I said, was on his lap.
And at the time that the defendant's making these comments to you, how many officers are on scene?
Just Officer Mir at this time.
And you?
Correct. I did request an additional unit because it was just not going anywhere. I did tell him multiple times that he needed to turn off the car, step out, and walk back. He said he didn't need to get out of the car.
Okay. And did you explain to him that he did need to get out of the car?
I explained that I was giving him a lawful order that he needed to get out of the car or he would potentially go to jail if he didn't comply to those.
Okay. And did he comply?
He did not.
And what did you do then?
Well, I did request additional units. That other officer working with us was on his way back to the city from another call. So I requested either Willoughby or Wycliffe respond to our location for additional backup.
Why is additional backup necessary?
You know, a rational person would get out of the car. Potentially, you don't know the unknown that's going on with him at that time.
Do you have any idea if he has any weapons or anything in the car?
None.
Okay. So no, you didn't know, or none, there weren't any?
I was unaware if there was any weapons or anything else in the car.
Okay. And was there anything that you said, or that Officer Mir said while you were on scene, that indicated that you were going to have some kind of physical altercation with him to lead him to be saying, oh, you're going to kill me?
No,
Okay. Never the officer's intent while you were there?
not at all.
Did you have your gun drawn?
No.
What did you have in your hand?
Flashlight.
And what were you doing with the flashlight?
Just looking in the car, just while I was talking to him, make sure I could see everything that was going on.
Okay. So how long are you there talking to him, trying to tell him, like, look, you need to get out of the car?
I mean, I couldn't give you an exact, but if I had to, maybe within 10 minutes, which is a very long time being on scene.
Do you normally take that much time, and are you normally that patient when you have somebody who's not getting out of the car?
No.
Okay. Why did you wait longer?
I basically delayed the situation because if we're going to do a vehicle extraction, meaning pull someone out of a car after giving so many different warnings, it's not a two-man job. It's really not even a three-man job. You want 4 people there for safety issues. One person taking a lane, just for potential traffic, somebody hitting us, and it's just usually a 4-person job. You can do it with 3, but so I was basically just delaying it and being calm with him as much as I could just to get other officers on scene to take further action.
You said that you need somebody there for traffic, so there's traffic that evening?
Yes,
Were there cars going by while you were talking to the defendant?
there was.
Now, where the defendant was stopped, can you describe that area a little bit, please?
It's 90 eastbound at the 189, like right around the 189.2 mile marker, which is right at the exit to get off at Som Center Road, which wouldn't be an ideal spot to stop a car.
Okay, and so where the defendant was positioned, is that an area where people are exiting?
People have to get over right where his car was at, like basically right in front of where his car's at to get off the exit. You don't have any other options.
Okay. And when you talk about getting other individuals there to do an extraction, is that a typical thing that you would do?
We do ongoing training with that monthly.
Okay. And with that training, it's not every traffic stop where you're going to be like, look, if you don't get out, we're going to extract you out of the vehicle.
No, I mean, most stops aren't going to that level, but
This one was?
this one was, there was indicators believing that he was possibly impaired, and we were going to investigate further.
Okay, and so with that, with there being a suspicion that there's impairment, you as a police officer, are you able to just let him go?
No,
Why not?
we can't just, if we have these indicators that are leading us to believe that he is possibly impaired, we can't just let him drive out on the road.
Is that a liability issue as well?
It would be a liability if we just let him go and he hit somebody or hurt somebody.
All So when you have even the other additional officers, the 2 more officers are there, does the defendant get out of the car?
He does not.
And what are you asking him at that point?
At that point, I believe there was 3 officers, Officer McNamara, a Wycliffe officer, and Officer Muir were at the rear of the car, basically coming up with a quick plan, so we were all in, I told him at that point that he was now under arrest and that he needed to step out of the vehicle.
And did he do that?
He did not.
Okay. And so what did you do next?
Officer Muir tried to hit one of the windows out. It did not work. I saw him put the car in drive. I told him not.
Who?
I saw Mr. McLean put the vehicle in drive, and I told him he would be getting additional charges if he took off, not to do it. He did not listen, and he took off. He fled the scene.
Okay. The area where you're stopping, I know you talked about it is close to an exit area. Where the defendant's vehicle is there, if you're standing at the defendant's front passenger window, what's behind you?
I mean, directly next to me, within probably 2 feet from me in the car, would be the guardrail.
And in terms of the other police cars and where the other police cars are situated, where are they in relation to the defendant's car?
They would be directly behind it, and then there would be another one taking the lane directly next to that.
Anybody have their police lights on, flashing?
Everybody had lights on.
Everybody meaning the officers?
The officers, correct.
Okay. Wait, when you say that you saw the defendant put the car in drive, what specifically did you see him do?
Reach his hand down and just put it on there and put it in drive.
So was the car already on then?
It was. He never turned it off from the different times that I told him to turn it off.
Okay. All right, when he took off, how close were you to the vehicle when he did that?
I was still right next to the vehicle.
What did you do then once the defendant took off?
I stood there for a second, kind of just, in awe, and then we all eventually got back to our cars and initiated a pursuit.
Okay. Officer Muir was the initial officer on scene?
Correct.
And is he the one who then took off first?
Yes, he would be the lead car following Mr. McLean.
So you've told the defendant to get out of the car, you've told him he's under arrest, and none of these commands seem to make any difference?
No.
And you've indicated to him if he actually leaves, there are going to be some additional charges.
I did.
Does he say anything to you at all?
I don't recall if he said anything else at that point, but he obviously just disregarded everything I said to him.
Okay, and during the course of the pursuit, were there any other officers that had to be involved in this as well?
State Highway Patrol, I believe, Menor, possibly Willoughby, the Wycliffe officer that was with us. There was several different departments. I did request State Highway Patrol, because they're usually in the area, that if they could put out spike strips eventually, that we were requesting that.
Why are you requesting that these other agencies get involved and put down the stop sticks?
I believe that it was a hazard to everybody else. It was a serious risk to anyone that was potentially driving on the roadway at that time. Again, that Terminator that was at the rear of the tire, you never know where that thing's going to go. I mean, I'm standing right next to it on the side of the road. The other officers, when he took off, were directly behind the vehicle. You don't know if he potentially put it in reverse. He could have hit those officers. The Terminator could have shot out and hit me as he was going.
Hang on a second. Overruled. You may continue.
Okay. All those factors played into what we were doing next. But him being on one tire, because that thing did pop the tire, but it takes a minute for it to completely deflate. So as he's driving, when that, I mean, shreds of tire are starting to come off of it. Once you get down to a rim, you don't know where that vehicle is going to end up. If there is other traffic, he could potentially lose it.
Overruled.
And he could potentially hit somebody else. He could hurt himself. There's just a bunch of different indicators, or not indicators, but all those things played into why we were continuing the pursuit.
And is it normal for you, just on your daily basis as an officer, to have that many other police departments involved and have stop sticks out in?
I mean, I guess it depends. You always have mutual aid, but a daytime's going to be a lot busier, and you're not going to have that, nighttime, like it's not as crazy, but you're going to have that luxury of having other departments able to back you up like that.
And where you're standing talking to the defendant, are you able to see his taillights from there?
I can't see him where I'm at, no.
Okay. Right, so at that point in time, you didn't know which way he was going, you just saw that he...
I just saw that he put it, I would believed it was in drive, but it could potentially be in whatever. He could have put it in neutral, reverse, or drive.
Okay. And when the defendant pulled out, were there any cars on the roadway?
I don't recall if like directly next to us at the time. I was more focused on him, but
Okay.
I did see the Terminator get caught in his back wheel well, like of the rear passenger tire as he was taking off.
And during the course of all this, you had said that you had a body cam on you.
Correct.
Okay. And was this incident, was everything recorded here?
It was.
Okay. Your Honor, for the record, I'm going to show opposing counsel what I've marked for identification that states Exhibit 3.
You may.
Officer Jones, I'm going to ask you if you can take a look at that. Tell me if you know what that is.
This would be my body cam from that night.
Okay, how do you know that that's your body cam from that night?
Because I reviewed it and signed it after watching it.
You see your initials are on there?
They are.
And did that fairly and accurately depict your body-worn camera in the recording from that evening?
It does.
Your Honor, I move for the admission of State's Exhibit 3 and ask to publish this for the jury.
Any objection? States 3 will be admitted.
Ready to go?
It is ready?
Yes, Your Honor.
Well, what's,
Nope.
whatever's on your screen should be up there.
When I'm looking at my screen, it has the video. Let's get rid of the rest of everything. Sorry about that. Okay,
We'll figure.
Camera, stop for a second. We didn't hear anything initially. Why is that? It's kind of annoying chirp.
The delay, I think there's, a 10-second delay before it actually starts with audio.
Okay.
I don't know what you're calling your mom for. Somebody has your back. That makes no sense. You need to start listening. It's not a debate right now. I'm already here. Tom, are you close? Copy. Central, can you send a Wycliffe or Willoughby unit down here, please?
Copy.
Now, we can see that there are some hand movements by the defendant. You can't really hear him. How about your ability to hear him? Are you able to hear what he's actually saying?
No, it's still actually very hard, but I know he was talking to his mother on the phone and just getting very animated and told her to record everything that was going on.
I mean, it's not going to do any good with one car. If he wants to leave, he's going to leave. No, I mean, I'm already committed right here. I'm watching him. I'm not walking back to the car. I mean, pulling up behind him's not going to do anything.
So who are you talking to?
One of I believe it's Officer Muir behind me.
Okay, so when we see the defendant animated in the car, is he talking to you?
No, he's talking to his mother. He's talking to the phone, I believe to be his mother.
Okay.
So do you want me to talk to your mom, your mommy, so she can help you, like, talk some sense into you? Well, you need to step out of the car so we can explain things. Okay. Here, roll that down so I can talk to her. I can't hear anything she's saying.
So when we're looking at the window here, how much is that window down?
Maybe realistically only an inch or two.
Okay, and is that making it easier or harder for you to be able to understand what he's saying?
It's making things a lot harder.
So when we're looking at this here, that the light that we're seeing in the window, where is that coming from?
That's from my flashlight, which is in my left hand.
Okay, and we see a face kind of down towards the right of that. Whose face is that?
That's mine.
That's a reflection then?
It is.
Okay.
Not slow, then get out of the car. Listen, here's the deal. If you do not get out of the car, listen. If you do not get out of the car, you're going to jail. Okay, well, it doesn't need to be like that, but you're talking yourself into it. Okay, that's fine. That's why we need to talk to you. I don't need to talk to your mom. Ma'am, you need to tell your son that he needs to step out of the car so we can talk to him. If not, he is going to jail. I can't hear you, but he is going to go to jail. You're a grown-ass man. I don't need to talk to your mommy. Okay? Well, go ahead and do me a favor and turn the car off.
I did nothing wrong. I did nothing wrong.
Turn the car off.
Okay, I did nothing wrong.
Turn the car off. Turn the car off. Okay, that's fine. We will. So turn the car off. What? Why? I don't want to kill you. You're talking like a fool. Yeah, you are. I guess you're so not concerned. Why are you yelling? Why are you yelling? Okay, well then step out. Oh, I'm so sorry I'm bothering you. We have some business that we need to handle. Yeah, we need to speak to you outside the car. Really? Do you know how dumb you look right now? You're eating chicken and not listening. Good. You're being recorded right here. Your stupidity will be shown right here. Okay, good. You are not listening. Okay? You are not listening. What's that? No, it's all right. Listen. Step out of the car. I am not debating with you and your mommy. Okay?
Now, in your involvement here, you were not the officer who initially stopped him, correct?
I was not.
Okay, so you would not have told him or asked him initial questions or told him why he was stopped?
No.
Okay, you're the second officer speaking to him?
Correct.
Okay. And when he's talking to you, what is he yelling at you about?
At one point, he was saying you, like he didn't understand that I wasn't the officer that pulled him over. He believed that I was the officer that pulled him over.
Okay.
And I had to tell him at one point, I didn't pull you over.
Okay. And you know Officer Muir pretty well.
I do.
Physically, do you two look very alike?
Not at all.
Okay. So for you, knowing that he's thinking you're the person who pulled him over, saying you, are you trying to explain to him that you're not the person who pulled him over?
Yes.
Okay, and still here, if you could point to like how open is that window?
I got this thing right now.
You press the red other way.
About right there is where it would be open.
Okay. And so when you're speaking to him the entire time, is his window up like that?
Yeah, it doesn't change at all.
And you're not able to hear him and what he's really saying?
It's very hard during the whole entire encounter, but I did my best.
Is that why you're talking so loud?
It is, because it's just hard to understand, or for him to,
And during this period of time, is there traffic that's going by?
there is.
All right, listen. I'm going to explain this to you. All right? Like I've already told you several times, you need to turn the car off and you need to step out so we can talk to you back there. Yes. Listen.
Tell me what's my problem.
You need to step out of the car or you are going to jail. I've already told you that several times.
What did I do?
All right.
Why do I need to step out of the car? What did I
Because
do?
we need to speak to you back there.
Why didn't he speak to me out
I didn't pull you over.
I said, why do he need to speak to me? Tell the person that here to come speak to me why he needs to speak to me.
Okay.
Get out here. Y'all hear this. You hear what's going on? Make sure you keep
You're making this way worse than it needs to be.
not keep recording. Keep recording.
You need to step out of the car. So we can speak to you.
Why do you need to speak to me when you speak to me right now?
Why was your hand on the handle of the door?
Every once in a while, the lock will pop, but I was seeing if it was unlocked. It obviously wasn't.
Car still running?
We have some
It is.
issues going on right now. Obviously, the issues you're not listening. Okay, this isn't a debate. I'm giving you a lawful order to get out of the car. You can talk to your mom all you want. I know I'm waiting until he gets here. I'm giving you a lawful order to get out of the car. Yeah, that's what everybody's doing. This is just basic 101.
No. I don't know if he's on the phone talking to whoever's on the other end or if he's talking to me at this point. Again, I'm just delaying it.
And then we'll go forward.
Would you normally be this patient?
Honestly, within a few minutes of someone not listening, I'm actually shocked I said that many times, like repeated myself that many times, but usually if we're not busy on a night and backup's right there within a few minutes, we would already been going with the vehicle extraction and had the person out of the car. This was just delaying for numbers for backup.
There's no reason to stop me. That's what I'm trying to tell you. Fine. So you can call the lawyer. You can tell everybody to come right here at Willoughby Hill in Willoughby at exit 189.
Hey, listen to me right now, all right? You are now under arrest, okay? I'm telling you you're under arrest. So you need to step out of the car or you will get dragged out of the car. So you either listen or you get out. Your window will get shattered. If you drive off, you're gonna catch a million different charges. So you need to listen right now.
Y'all shadow my window, kill me then kill me.
Step out of the car.
There's nothing wrong with gay y'all.
You are under arrest. I don't know how many times I need to fail you. You are not listening.
What's the reason why I'm under arrest?
Obstructing.
Obstructing what?
Cool. He's taking off. Go ahead. You're going to get in a lot more trouble.
Why did you say at that point in time he's taken off?
That's when I saw his hand put the vehicle drive or reverse. I wasn't sure which one.
So with all these comments that he's making to you and everything that's going on, no matter what you tell him, he's not getting out of the car?
Correct.
And Officer Muir, from your understanding, has already spoken to the defendant, explaining the reason and asking questions prior to this.
Correct.
And do you normally tell people, look, we're going to get you out for field sobriety tests, or you just say get out of the car?
Just get out of the car. My partner needs to speak to you at the rear and give you some instructions.
You are going to jail one way or another.
Breaking it.
You're laughing disbelief?
Yes.
Somebody call it. Central, he just took off by those P for going eastbound. Copy, just took off by the OSP.
That it?
Yes, Your Honor. So in terms of what we observed here, that your conversation with him lasted approximately how long?
If I had to guess, possibly 10 minutes.
10 minutes. And no matter what you told him, he wasn't getting out?
No.
Okay. And when he took off, you could see, at least from the video, you could see part of where you are, and how many other officers are there at that time?
3 other officers that were to the rear. The one officer, Officer Muir, who was trying to shatter his window.
All right, and this person that you were speaking to, that you gave that lawful order to get out of the car, that decided to take off, do you see that person in the courtroom here today?
I do.
Can you please point the person out and describe what the person's wearing?
He's wearing a gray or tan polo. He's right there.
May the record reflect the identification, Your Honor?
Record may so reflect.
May I have a moment, Your Honor?
Yes.
All right, I just want to, a few more questions. After he takes off, is there a pursuit?
There is.
And during the course of that pursuit, who is in charge charge of determining whether or not that pursuit will continue.
I am.
Okay. And based on what you're observing on the roadway, did you feel that it was necessary to continue that?
I did.
Okay, why was that?
He started off at a very high rate of speed. Officer Muir was the lead car. Officer McNamara was the one that was calling out everything that was involved in it. Weather conditions, speeds, traffic, all those different things. He started off at a high rate of speed, and once he said that he was starting to drastically slow down, traffic was light to non-existent at that point based on where they were at. They would have already gone past the traffic, and when he was slowing down, there was no way they were catching up to any traffic in front of them. We were all behind them, so it was all contained where we were at. So
when you're putting your arms out like that, do you mean that your cars were across the roadway?
yes, and everything behind us, I even called out over the radio to whoever was the last two cars to just kind of like hang back and stop traffic, meaning you weren't letting any cars in front of them.
Why not?
Depending on what the outcome was, you don't know what I mean, it was a serious risk just him being on the roadway. So with us being there, it just contained it, cars to the rear, and he was the only one in the front, which he was slowing down drastically, and there was no traffic anywhere there.
So does it matter in terms of somebody being impaired and taking off, does it matter if it's daytime or nighttime? Is one less dangerous than the other?
Not at all. I mean, they're both very dangerous. I mean, it might differentiate, or it might be a little bit different during the day when you got a rush hour compared to 2 o'clock in the morning when traffic's a little bit lighter, but they're both very dangerous either way.
All right. And initially, as the defendant is driving at the high rate of speed, are there other vehicles that he has to maneuver around?
Could you repeat that? I'm sorry.
When the defendant takes off initially, are there other vehicles that he has to maneuver around in front of him on the roadway?
Absolutely. There was a few semi-trucks, I believe, and some other vehicles initially. And then once we had it contained, it changed.
Okay. And when you got to see the final state of the vehicle, what was the status of all the tires?
All 4 tires were blown out at that point. I mean, the original from the Terminator, that tire ended up shredding and was flat like initially, and he was riding on 3 tires at that point. But the slow rolling, when he was finally slowing down drastically and the trooper spiked him, all 4 tires got popped at that point.
Okay, nothing further at this time. Thank you, Your Honor.
Thank you. Cross-examination, Mr. Lemak.
Morning.
You said sort of towards the end there, the traffic is only a little lighter at 2 a.m. on a Sunday as opposed to a daytime rush hour.
Correct.
Okay. So what we saw on here is just a little bit lighter than what would normally be daytime around 5 o'clock on that highway.
Rush hour and 2 o'clock in the morning, completely different, yes.
So completely different. Right.
There's a big difference between a rush hour and 2 o'clock in the morning.
Exactly. There's a big difference, not a little lighter.
Okay,
Huge difference. Completely opposite, correct?
sure, if you want to use those words.
Wow. I would like you to use those words. That's why I'm asking you.
It's very drastic. It's different, yes.
Yes. All right. That's what I thought. I just want to clarify because you said it's a little lighter
Okay,
at 2 a.m. on a Sunday. So it's actually not a little lighter. It's a lot lighter. Completely. Correct?
correct.
Okay. Thank you. You also said earlier you guys frequently use the Terminator?
We do.
Okay. I'm curious, how many traffic chases have you been in throughout your career?
That's a good question, but quite a few.
Like 20, 50, 100, 200?
More than 20, less than 50.
Okay.
somewhere in that ballpark.
So more than a couple hundred's a lot. How long have you been a police officer?
I didn't say a couple hundred,
No,
I s-
I agree. How long have you been a police officer?
almost 18 years.
18 years?
Yeah,
Okay. And in that 18 years, you've done between 20 and 50 chases.
that's a ballpark. It could be a little bit more, it could be a little bit less.
Okay, so in that area.
Sure.
but less than a couple hundred.
Yes, less than a couple hundred.
Significantly less. than a
Yes.
couple. Okay. You had said that you couldn't hear him very well. It seemed while we were watching this and listening that the only thing you couldn't hear was his mom on the phone, apparently. Because everything else you were answering and you were telling him, and he was giving you answers, maybe not what you wanted, but you seemed to be conversing.
Doing my best, yes.
Okay, all right. And you also said that he was being loud as well.
He was very animated, yes.
And, well, yeah, we saw his hands in front of him.
Not making a lot of sense to a lot of things. If you saw me, I was standing there at a lot of times, and he was just talking.
I appreciate you wanting to expound, but let me ask the questions and then
Sure.
answer my questions. Thanks, I appreciate it. So you had mentioned just now that he was very animated, and we saw, inside his car, his hands were, in front of him like this, speaking.
Yes,
All right, but that was the very animated, not flailing about, but moving his
that was the animation that I'm explaining, yes.
Thank you. You'd also said that during this traffic stop, that you were delaying it because you wanted to get more people there, correct?
Correct.
Okay. And so it was about 10 minutes before Mr. McLean left, correct?
In that ballpark, like I said, correct.
You'd also mentioned earlier that the way he was stopped, and you were all stopped there, traffic would have had to get off the exit immediately, create a hazard for that exit in 91.
Correct.
Okay, so it would have been very difficult and hazardous for somebody, a regular person just driving by, not part of the stop or any other police cars there, would have been in danger themselves trying to get off because it wasn't safe.
It was not a good area whatsoever, yes. It was putting other people at danger and ourselves for potentially cars getting hit, us getting hit.
Because there really wasn't much room to get off the exit without coming close to you.
No, and then when people see our lights and stuff like that, they kind of
Well,
freak out too.
That's a general thing that, that could happen at any time, anywhere, safe, unsafe, bad spot. That's just a general statement of when people see the police lights.
Do you mind
They
if,
might look at them and drive into them, correct?
correct, do you mind if I explain just, they would have to go a
No,
little
no,
bit further?
actually, I do mind if you explain.
Okay,
I just
sure.
want you to answer the questions.
Sure.
All right. And I'm not trying to shut you down, it's just, I have specific questions.
I understand.
I'm looking for answers. They're all up there? May I approach, Rainer?
You may.
Show you one of the pictures we saw yesterday. It's in here somewhere. It is a dash cam still. Is that on there? Is it? I didn't see it. Oh, okay.
Yeah, maybe they're underneath the map.
I know, yep, I know that. All right. We hand you what is exhibit, or states exhibit 6A. You can take a look at that and see if you can tell me what that is.
It's me standing next to the car with the other officers behind it.
Okay. And you can see about how far is the bridge from where you guys are?
Maybe like 30, 40 yards.
The bridge is 30, 40 yards from where you are?
I don't know exactly, ballpark.
Okay. You ever play football?
I did.
All right. You think that's a 30-yard run to that bridge?
How far do you think it is, sir?
I got to say that's over 100 yards easy.
Okay. Well, I guess I was a bad football player.
Well, I didn't play football.
Okay.
Swimming, so I was a small fellow. So, would you agree that's over 100 yards away?
I wouldn't agree that it was 100 yards away, but
You would not?
no.
Okay. Right. We watched the body cam, and you said there was a 10-second delay on the audio?
Somewhere in that ballpark.
Okay.
It's 10, 15 seconds, something like that.
I was under the impression that there was actually a 15-second look back, similar to the dash cam. I thought that's what we learned yesterday. That is not the case with your body cam?
My body cam's the same as everybody else's. I'm not sure what the delay is on it. I turn my body cam on when I get out of the car.
Okay. So you say you got out of the car and 10 seconds later you are several questions into speaking with Mr. McLean.
I'm not. My body cam goes on before I have any encounter with anybody.
Okay. Oh, all right. Or maybe during. Okay. Is calling Mr. McLean stupid or mocking his mommy a de-escalation tactic?
That was just talking to like an adult.
Calling him stupid and saying
I
he
don't.
doesn't need his mom.
I don't recall calling him stupid.
We just heard it. You see, you look stupid right now.
Oh, you look stupid. I did not call him stupid.
Oh, okay. Right. But that's not a de-escalation tactic. That's just you talking like an
That was me just talking. Yes.
Okay. And then you were not struck by Mr. McLean's car, correct?
No.
Okay. As a matter of fact, he never even came close to hitting you, correct?
No.
Okay. And you said that you weren't sure if he put his car in drive, neutral, or reverse, but he certainly didn't put it in sideways, correct?
No.
Because there is no way to move your car sideways, correct?
Unless he turned the wheel and it went sideways.
His car goes sideways if you turn the wheel?
Not directly sideways. If he turned the wheel, he could potentially run into the guardrail.
If you feel, in your opinion, if he had not gone anywhere, cranked that wheel all the way right, and stepped on the gas, he could have struck you?
Probably not. No. I'm just saying he could potentially
No,
go
like you said,
sideways.
Probably not. That's all I need.
Okay.
Okay. Go back to the video we just had. His dash. Exhibit 3. I'm going to get to a stop, Your Honor.
Let me know when you're there.
All right. All right.
Reason why I'm under arrest?
Obstructing.
Obstructing what?
223,
He's taking off.
Yeah, so it's
Go ahead. You're going to get in a lot more trouble.
223, so that's when he put it in drive, correct?
Correct.
And that's
Right
by
there.
the timestamp, and
Yes.
we just saw him put it in drive. All right. You're aware that at 2:23 and 20 seconds, behind him is Officer McNamara, and that's when he pulls his gun out and he holds it up around his head, behind Mr. McLean's car.
I wasn't aware of that.
Okay, you didn't see any of that?
I did not because I was directed to him.
All right, so you're looking in there, but Mr. McLean is looking forward, ahead, and he's in view of his rearview mirror, correct? He can see that from where he's sitting.
Objection.
Sustained.
Is Mr. McLean in his car?
He is.
Is he sitting in the driver's seat?
He is.
Is there a rearview mirror on his windshield in front of him?
There is.
Is it obstructed by anything?
What was the question?
Is it obstructed? Is his rearview mirror obstructed between himself and the mirror?
I'm not positive, but a normal stop would have our spotlight hitting that mirror to kind of blind them a little bit.
Correct, correct. But my question was, is there anything in between Mr. McLean and his rearview mirror that would keep him from seeing anything in that rearview mirror?
I'm not sure.
Can you see anything here that shows that there's anything in the way? And do you recall seeing anything unusual floating in between Mr. McLean and his rearview mirror?
I do not.
Okay.
I don't recall. That's
Right. Fair to say you would have remembered something somehow being in between them, blocking his vision of a rearview mirror, right? That's reasonable to say?
correct.
Okay. And you had mentioned before that typically a spotlight is shining on that mirror,
Correct.
All right. But if someone were to be blocking that spotlight, it would no longer be shining in that mirror, correct?
I can't
In
say
theory.
what was going
In
on
theory.
because I don't know what was going on in that
I
situation.
got you, but let me ask the question, make it clearer. In theory, if someone is blocking that spotlight from hitting the rearview mirror,
Yes,
that would no longer impede.
it would allow somebody to be able to see through the mirror,
Thank you.
if that's what you were trying to get at.
Yes, thank you. No further questions.
Redirect examination.
Thank you, Your Honor. During the course of talking to the defendant, is he on the phone with his mom the whole time?
Pretty much the whole entire encounter. His phone's at least on his lap and it's lit up most of the time that I can see it.
Picking up and looking at it and talking and showing it to you.
Correct.
So while you're watching what he's doing, he's actually looking at his phone and looking at you
And eating chicken.
and eating.
Hang on. Sustain as to end. Rephrase your question, please.
So while you're talking to him, what is he doing the entire time?
Talking to someone else and me at the same time.
And this particular vehicle, actually, I'm going to show. I'm going to show opposing counsel a mark for identification as State's Exhibit 6C.
Yes, you may.
I'm going to ask you to take a look at Exhibit 6C and ask if you recognize what that is.
That's the defendant's vehicle.
Now, was there anything that you noticed about the windows on that vehicle?
They were tinted. The front windows were tinted.
And the rear, that rear window, that tinted as well?
It appears so.
Okay, and there are some things that are on there, some like little,
Stickers.
yeah, those are on there as well.
Correct.
And are you able to see at all in the back seat and see if there's anything piled in there or if there's anything in that back seat at all?
From this view in this picture, no.
And when you're talking to the defendant, did he have something on his head?
He had a bucket hat on.
Okay. Mr. Langmack asked you a bunch of questions about, oh, did you get hit? Right, with this. When you have, during the course of your work as a police officer, have you seen individuals who been driving on the rim or lost tires?
I have.
Sustain. Rephrase your question.
Okay. In this situation with a Terminator stick and the use of a Terminator stick, what's the purpose of a Terminator stick?
In case the person does flee the scene,
What does that stick do?
it deflates the tire. It pops the tire and eventually it goes flat.
Okay, so if it pops the tire, do you know whether or not he's going to put the car in drive and turn his wheel?
I don't know what his next move is at that point.
Do you know whether or not when he puts it in drive and he decides to go away at a high rate of speed, if that tire is going to fishtail him?
Anything's possible.
Is it any less of a risk to you in this situation, even though he didn't hit you?
No, like I said, I've seen those things shoot out, and that Terminator did shoot out. It just, after he took off, it went backwards and shot out, but could potentially hit me.
Now, the question that was also asked is about daytime, nighttime. When you have somebody who has a tire that's deflated, that is impaired, and is taking off at a high rate of speed, does it matter if it's daytime or nighttime?
It does.
Okay. And here, with it being nighttime hours and there being semis on the road, other cars, is that still a risk to those individuals on the roadway?
It is.
And it doesn't matter that it's nighttime, it's still a risk.
Correct.
And in looking at that, you could see in your video, you could see, you said there were semis?
Correct.
Other cars? Okay. Is it still then a risk to even property at that point in time?
It is.
And in terms of the chases that you've done in your 17, 18 years of work as a police officer, when you look at that, who determines the chase? Is it the defendant's behavior that determines whether or not you're going to chase a vehicle?
There's a lot of different factors that play into it.
But for the defendant's behavior here, would you have gone on that chase?
Yes.
Okay, you would have gone on the chase because of his behavior?
Correct.
Okay. So if he had not done that, you would not have had a chase?
No.
And Mr. Langmack asked you a question about the area of the stop and the football field, and was it 100 yards or whatever? And you said that you were trying to explain that particular area. Can you explain what you were going to say about that area? Tell me about the area where this occurred.
I don't know. It's hard to explain, but someone would potentially, where we were parked, someone would potentially just get over right at that location to get off the exit ramp. I'm not positive on the yardage or anything like that of how far the bridge was, so I apologize if that's not 100% accurate. But a car would have to go further and get off almost last minute to get off the exit instead of getting off where we were at, like right in front of where we were at. So
I'm going to show you again what was marked as State's Exhibit 6C, and I'm going to draw a red line on here and point to there are some dashes on the roadway. What do those indicate at that point? Are they different from the normal lane lines?
it's, you're normal, you can get over there.
Okay, and when you start seeing the dotted lines that are a little closer together, does that signal that you're getting off?
It shows
the
that the exit ramp's right there.
Okay.
And start getting over.
So it's different. The markings on the roadway are even different at that point in time.
They're starting to get smaller, correct?
And when they start to get smaller, that's where you're getting off on the exit.
Correct.
And do you normally see on the roadway those types of markings getting slower and closer together, like miles down the roadway?
No.
Pretty close to the exit?
almost at the exit, but yes, before you get off at the exit.
Okay, thank you. Nothing further, Your Honor.
Recross-examination.
One moment. Obviously, either you nor I, admittedly, can tell the exact measurements of that. Could be 110, could be 80 yards, could be 200 yards. I don't think it's 200, but obviously we can see the picture there, correct? So we can see it, everyone will be able to see the picture. That's where the car was. That's an accurate representation of where that stop was. It's not a doctored photo, correct?
Correct.
All right, so we can see the bridge in the distance. You got to go under the bridge, and then that's when you start, making that curve afterwards to get off at 91, correct?
Can I
Curving before the
can I
bridge.
say something? The bridge is not exactly where you get over. You still get over
No.
before
That's-
you
yeah,
get to
that's not
that
what I
bridge.
said. No, you got to get over before the bridge, but you got to go under the bridge before. You're
Correct. You
completely
go
off
under the bridge
highway.
and then you're going to make a big curve
Curve back
around.
Right.
But to get over is before that bridge.
Well, yeah. I mean, you don't want to make a right turn like it's not an
If
intersection.
you're waiting until you get to that bridge, you're way too far, and you're gonna cut somebody off getting off that
Correct.
exit ramp.
Correct, which is why there's a long exit lane before that bridge.
Correct, but it's drastically before the bridge. All right, I'm not gonna explain drastically, but you get over before the bridge.
Absolutely, absolutely. And at this point, this stop is significantly before the bridge.
I don't know about
100
significantly.
yards or more.
I don't know the yardage.
I got you. I think we can
Established
move past
that. I'm not sure how far away we are, but we're
I
close.
got you. I'm done with the bridge. When you were standing next to Mr. McLean's car and it went into drive, you could see his front tires? Well, you could see the front passenger side tire? From where you
Yes.
are? Okay. Did you see it moving, canting inwards or anything?
I mean, I don't think I was realistically paying attention to his tire at that time, so I don't recall, but
So you don't recall looking at his tire?
I don't recall looking at his tire, but yes,
So at that point, you were not concerned with him driving into you. Otherwise, you would have looked at the tire possibly and said, that's not right.
I don't know how to answer that.
You didn't.
I backed up a little bit when I saw him put the car in drive or reverse, which was unknown.
Right, at that point, you were.
I backed up
you
a
were
little
at the
bit
window.
because I knew he was taking off.
Okay, let me ask a question before you answer it. You were at the window, and then you saw it go into drive, correct?
Not drive or
But-
reverse, but
so-
yes, I saw it go into gear.
Okay, you saw it going into a gear.
Mm-hmm.
And then we saw you back up, away from it,
Correct.
All right, and at that point, between then and when he took off, you didn't go anywhere else, you didn't run anywhere, you didn't jump over the guardrail, you just stood there, correct?
The car wasn't coming at me, no.
Correct. So it left, and you stood there even afterwards for a little bit, like, wow, that's crazy. And then you sort of walked back.
Ask a question, please.
You walked back, and so you walked back casually to your car, not running, correct?
Well, I know the other two officers are taking off first and already running to their car, so yes, I was the last one in the pursuit.
Okay, no further questions.
All right, officer, you may step down. Thank you.
Thank you.
Yes. All right, the state of Ohio have any additional witnesses?
Your Honor, at this point in time, the state would rest pending submission of our exhibits.
Prior to that, I'm going to read stipulation that was entered into between the parties. Now, a stipulation is an agreement between the parties regarding certain evidence, and you're to accept that stipulation. And since both parties have agreed to it, then no further evidence is necessary to establish the facts that the parties are agreeing to. In this case, it's been agreed to, what the stipulation reads is, now comes the state of Ohio by and through Charles Colson, Lake County Prosecuting Attorney, and Taylor Linden and Emily Johnson, Assistant Prosecuting Attorneys, and hereby enters into a stipulation with Charles Langmack, Esquire, the attorney for the defendant, and the defendant, Christian McLean, to the following. As to count 4, the parties stipulate that the defendant has a prior conviction for operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them within 20 years of August 31st, 2025, specifically in the Garfield Heights case number TRC 1708299, dated January 25th, 2018. And that stipulation was entered into by the attorneys for each side as well as the defendant, and it's been marked as joint exhibit number 1, and you'll have this with you in the jury room when you're deliberating. You go, Mary. Now, with that said, then, the state of Ohio, as they indicated, has rested. That means they have presented all the evidence and testimony they intend on presenting in this case. The next step in the trial is to afford the defendant an opportunity to present evidence if he desires. He's not required to do so. But before we get to that point, I need to address some legal matters with the attorneys outside the presence of the jurors. So you're going to take a break right now. We're going to stay in here and do what we need to get done. And then we'll bring it back in and continue on. So I do need to advise you still, even though the state has rested, you're still not allowed to talk about the case, the state's case, anything having to do with the case at all, with each other, with anyone else. Please don't let anyone talk about it with you. You're not to investigate or research any issues involved in this case. So what I'll ask you to do is you're going to file in the jury room, take a break. If you need to use the restroom, want to step outside for a second, fine. But then I'm going to ask you to come back into the jury room. I don't want you waiting out in the hallway, just hanging out there. So when you're done with your brief break, then wait in the jury room for us, please. And then Stan will bring you back in when we're ready.
All rise.
You may be seated. All right. Sorry about that. Ms. Linden, for the state now, you move for the admission of your exhibits. I have that I've admitted at least 5A through K, 1, 2, 3. I'm not sure if we actually admitted 4, 4A, and 4B. 6A and B, and then 6C. You did not identify 7, correct?
Correct, Your Honor.
So was 4A and 4B admitted? Those were the poster.
I
This.
just asked to publish 4 and 4A, but we didn't do 4B, and I would move for the admission of 4B, which is the small
So 4 and 4A were already admitted?
I believe so,
Okay.
Your Honor.
Any objection to any of
Right,
those?
published.
All right, those are all admitted then. And then there's 6A and B, those are screenshots that were identified by Officer Muir.
And there's also now
6C.
so I would move for the admission of those screenshots.
Any objections to any of those, Mr. Lingmack?
No.
All right, 6A, 6B, and 6C will be admitted then. So we don't even have 7, right?
No, Your Honor.
Okay.
And I don't believe that, I know that I talked about the Terminator stick, but I don't believe that since that one was separate, I don't believe that I moved for the admission of that, but I would do that at
Yeah,
this time.
that's right. 5A was actually, wait, is 5A the Terminator stick?
Yes, it is.
A picture of it or the actual stick?
The photograph of it.
All right. Yeah, that's right. That wasn't admitted. So, any objection there? All right, 5A will be admitted also.
And note 3 was admitted. We have 3A is the clips. So with each of those exhibits, there's the numbered ones, but the A's are the clips that were shown in court.
So that's for 2A and 3A.
Yes, Your Honor.
So
1A, 2A, 3A.
1A, 2A, 3A. So 1A, 2A, and 3A are what's going to be actually admitted and given to the jury. But 1, 2, and 3 will be made a part of the record so that we have that in the record if that's ever need to be referred to. And so 1, 2, and 3 are the actual full, complete videos in their entirety. And 1A, 2A, and 3A are clips that were shown to the jury, and that's what's going back to the jury.
Yes, Your Honor.
All right.
Thank you.
Anything else for the state?
No, Your Honor, not at this
Mr.
time.
Langmack, on behalf of the defense, anything you care to address?
Yes, Your Honor. We got Rule 29, even in the light most favorable to the prosecution, we believe they have not proven beyond reasonable doubt any of these 4 charges. And certainly, the greatest issue in count 1 is the substantial risk of serious physical harm to the person's property. When you watch the video of him driving off with right rear flat tire, despite the use of the word swerve and jerking, we saw him swerving or jerking. So lane changing and driving. There may have been little bits of tire coming off, I think.
Little bits? The whole tire's missing.
Well,
So the whole tire went somewhere. It's not little bits.
Well, we saw it roll off to the side into the median area. We certainly saw that, but at some point it was stated that pieces were coming off. We couldn't see them. I mean, I'm certain that it happened, but as far as
Well, I'm looking at a light and the evidence in a light most favorable to the state.
Oh, I am aware. I'm aware. And,
Well, then it did happen for that purpose. Because the officer testified to that.
he testified that those happened. So I'm not saying it didn't happen, Your Honor.
Oh, I thought you just
I'm
said
just
you're
saying-
not sure that happened.
Oh, no, I'm saying I didn't see it. I mean, I couldn't see the little bits come out. We did see the tire kind
I
of
know,
roll
but
off.
I thought you said you're not sure that happened, meaning the pieces coming off.
No, it certainly happened. I mean, we saw the tire afterwards. It had to go somewhere. Not a question. I'm just talking as to the substantial risk of serious physical harm to persons or property. It's that aspect of it. The obstruction, certainly, he was not cooperative at all initially. The stop, 10 minutes from the stop to when Mr. McLean left scene, and portions of that were delay on the part of one of the officers. It certainly is not an egregious amount of time. Was he not cooperating for a little bit? Yes. Were there proper de-escalation tactics employed? I would say no, quite the opposite. I mean, mocking him was probably not the best idea. And as far as the OVI, other than there's a smell of an overwhelming smell of Chick-fil-A, and also the odor of an alcoholic beverage, and the potential bloodshot or glassy eyes, which we've seen video or picture evidence of that. I'm assuming would have come in at some point once he was in custody. Other than that, we have no evidence of any impairment other than the initial, when he's driving around the curve, going from that 90 to 271 break, heading 90 eastbound. He's going around the curve, getting onto continuation of 90 eastbound, crossing over these stripes. But then when Mr. Klein pulls over completely out of the roadway, and after, when he leaves the scene, is driving, although quick and fast, which certainly is not a sign of impairment, whether it's there or not, it's just driving fast. You go out there right now and see 20 people doing it at this moment.
115 miles an hour, we'd see 20 people doing that right now?
Well, 100. The officer was going 115.
We'd see 20 people going 100 miles an hour right now. We went out
Maybe
there.
not 20. Well, we could find them. And I think we could have the officers attest to that as well. So I'm not saying it's good or excusable to go 100 because someone else is. I'm just saying that's not evidence of impairment. And despite the language used to swerving and jerking, I played a clip where he had jerked the wheel several times. I went back and said, okay, tell me where it was. Right there. And he would admit, well, it happened even though we couldn't see it. It's hard to imagine that video evidence is not capturing what we can see. I feel that is its primary purpose in existence. When you have video evidence, that is what we're seeing. That's what you saw at the time. That is a representation of what happened. This isn't some other random video. That was the incident. He's changing lanes. Doesn't cut anybody off. He's not running people off the road. He's not fishtailing. He's not swerving. He's not trying to cut through the median or running off the roadway. I mean, his driving was, except for the speed, not that unusual that you see every day on the highway. Even the swerving inside his lane. Not too many people drive dead straight the entire time they're driving. I think that's just common sense. There's certainly no field sobriety test given. There's no breathalyzer results. He refused.
I'm allowed to consider that.
But I mean, there's nothing. We have nothing other than I think I smelled Chick-fil-A and alcohol, and there was a full, non-open beer can in the back seat, and then a bottle of Tito's vodka in the trunk, closed. Nothing that says anything that he was drinking then, before, or day before, or anything at all. All we have is, I smelled something, and his eyes were bloodshot and glassy. And frankly, I don't think that's enough on its own. Even with the driving before the stop. So, Your Honor, I would ask that, even with the light most favorable to the prosecution, we ask for a Rule 29 dismissal.
Well, the court has considers the evidence that was presented, and I did this so in a light most favorable to the state of Ohio, as I'm required to do, and considering the evidence in that light, the court finds that there's more than sufficient evidence for the state to sustain its burden regarding each of the 4 charges. I'm going to overrule that motion. Is there anything else, Mr. Langmack, at this time on behalf of the defense?
One more.
I am going to provide a flight instruction to the jurors, and I have it here. I'm going to show you what it's going to say. I did some research, and while it's not appropriate for the fleeing and eluding charge in itself, because that is an element of the charge, it is appropriate for other charges as long as a proper limiting instruction is provided, and I've done that. So I guess I want you to know what the instructions are before you make whatever decisions that you need to make as well. Let me make this larger for you. That's too big. Hang on. So it's obviously highlighted there. It's a standard OJI instruction, flight instruction right out of OJI, but I've limited it to multiple times to counts 2, 3, and 4. In the last sentence, I specifically tell the jurors they're not to consider this evidence in deciding whether the defendant is guilty or not guilty of the offense charged in count 1. It does address the concern that you mentioned earlier, Mr. Langmack, in terms of, I think the third sentence, if you find that the facts do not support the defendant fled the scene, or if you find that some other motive prompted the defendant's conduct, or if you're unable to decide what the defendant's motivation was, you should not consider this evidence for any purpose. That's the issue you raised earlier, and the instruction addresses that. So I am going to provide this instruction, unless I mean, you could put an objection, but I don't know if there's any other thoughts anyone has about the instruction itself, or any changes or modifications to this instruction that you want to add. It is, again, the standard OGM with the limiting portions that I put in there. Anything for the state on the instruction?
No objection.
Mr. Langmack?
Yeah, I still maintain the objection. I mean, certainly it does say in there, this is only good for 2, 3, and 4. You know, forget about it when you're thinking about 1. I just think it's
We do that all the time.
Good to say, but I don't think it's appropriate.
All right. So you're objecting to giving the instruction overall. I get that, but I am. Is there anything you want to change about this instruction itself?
No.
Okay. All right. Then now we'll take our break, and you guys can chat. All right, ladies and gentlemen, as I advised you before the break, the state of Ohio is rested. The next step in the trial is to afford the defendant an opportunity to present evidence if he desires. Again, he's not required to do that. Mr. Langmack, is the defendant intend on presenting any witnesses or evidence in this matter?
No, Your Honor.
So you would rest at this time?
You're right.
All right. I'll see counsel at sidebar real quick. All right, ladies and gentlemen, as you heard, the defense is also rested. That means each side has presented, in this case, all the evidence that it intends on presenting. There are 2 steps that remain to be completed before you get to begin your deliberations. The next step is that I'm going to provide you with the instructions of law that are to be applied in this case. After that, the parties get an opportunity to make their closing arguments, and I'll give you some concluding instructions after that. So at this point, we're going to start with the instructions. Again, as I told you at the very beginning, you're going to be getting multiple written copies of these instructions in the jury room with you when you begin your deliberations. So I'm not expecting you to memorize what I'm telling you here, but I am required to read them to you, so I'm going to do that at this time. And I'm actually going to also put them up on the large screen, so if you want to read along with me, you can, but you don't have to. You can sit back and just listen as well. But with that said, let's get started with that. You have now heard all the evidence. The court and the jury have separate functions. The jury decides the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept the instructions and to apply the law as it is given to you. You are not permitted to change the law nor to apply your own idea of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he's been charged with criminal offenses. The fact that it was filed may not be considered for any other purpose. The plea of not guilty entered by the defendant to the charges is a denial of the charges and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of each of the offenses charged in the indictment. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt that's based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from witnesses, the exhibits admitted during the trial, any facts that are agreed to by counsel, and any facts which the court requires you to accept as true. In this case, counsel for both sides have agreed upon a written stipulation, joint exhibit number 1, concerning certain evidence, and this stipulation will be with you during your deliberations. Evidence may be direct or circumstantial or both. Direct evidence is testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts, which naturally and logically follow according to the common experience of mankind. As an example, if you wake up in the morning and see the ground is covered in snow, that is circumstantial evidence that it snowed earlier. Likewise, if you see human footprints in sand, that is circumstantial evidence that someone had previously walked there. To infer, to make an inference, is to reach a reasonable conclusion of fact, which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or opening statements or closing arguments. The opening statements and closing arguments are designed to assist you. They are not evidence. You must not speculate as to why the court sustained an objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Statements that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. If the court sustained any objections concerning any statements made during opening or closing arguments, you must disregard such statements made by any attorney. Exhibits as well as testimony related to them have been introduced. You will determine what weight, if any, the exhibit should receive in light of all the evidence. If there's a copy of an exhibit, you should consider it the same as an original. If there are deletions or redactions, you must not consider those parts. The exhibits are identified by their numbers or letters. The fact that numbers or letters may be missing or omitted shall not be considered by you for any reason. There are several reasons this may occur. An exhibit may not have been submitted by the party who produced it or identified it during the trial. Excuse me. Or the court may not have admitted an exhibit because of legal or procedural reason or ruling. Do not draw any inference because you do not have a particular exhibit. I'm sorry, excuse me. You will have with you in the jury room as exhibits video recordings which were introduced into evidence. If you wish to view any of these recordings, there is equipment in the jury room which the bailiff will assist you in setting up and instruct you on how to use so that you may consider this evidence. Evidence was received that the defendant was previously convicted of operating a vehicle under the influence of alcohol and or a drug of abuse. That evidence was received only for a limited purpose. Specifically, that evidence was received in this case because a prior conviction is an element of the offense of operating a vehicle while under the influence of alcohol, a drug of abuse, or a combination of them as charged in count 4. This evidence was not received, and you may not consider it to prove the character of the defendant in order to show that he acted in conformity or in accordance with that character. You may consider that evidence only for the purpose of deciding whether it proves the defendant was ever previously convicted of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. As jurors, you are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the test of truthfulness, which you apply in your daily lives. Now, these tests include the appearance of each witness upon the stand, the manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things concerning which the witness testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding this testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem to be proper. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. You should not consider, you should not decide any issue of fact simply based on the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence will be the force and weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. In this case, testimony has been admitted indicating that the defendant fled the scene. Now, regarding this evidence, as to counts 2, 3, and 4, you are instructed that the defendant's flight from the scene does not alone raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find that the facts do not support that the defendant fled the scene, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support that the defendant fled the scene, and if you decide that the defendant was motivated by a consciousness of guilt regarding counts 2, 3, and 4, you may, but are not required to, consider that evidence in deciding whether the defendant is guilty or not guilty of the crimes charged in counts 2, 3, and 4. You alone will determine what weight, if any, to give this evidence. You shall not consider this evidence as consciousness of guilt in deciding whether the defendant is guilty or not guilty of the offense charged in count 1. Now, as for the specific charges, in count 1, the defendant is charged with failure to comply with an order or signal of a police officer. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about August 31st, 2025, in Lake County, Ohio, the defendant, Christian McLean, operated a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from the police officer to bring his motor vehicle to a stop. Now, the following words contained in the charge set forth in count 1 are defined as set forth below. Operate means to cause or have caused movement of a vehicle. Motor vehicle means any vehicle, including mobile homes and recreational vehicles, that is propelled or drawn by power other than muscular power or power collected from overhead electric trolley wires. Willfully, a person acts willfully when it is his specific intention to cause a particular result. To do an act willfully is to do it intentionally as opposed to accidentally, carelessly, or unintentionally. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to elude or flee. Voluntary intoxication may not be taken into consideration in determining the existence of a mental state that is an element of a criminal offense. Voluntary intoxication does not relieve a person of a duty to act if failure to act constitutes a criminal offense. However, evidence that a person was voluntarily intoxicated may be admissible to show whether or not the person was physically capable of performing the acts with which the person is charged. Police officer means every officer authorized to direct or regulate traffic or to make arrests for violations of traffic regulations. In count 2, the defendant is charged with obstructing official business. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about August 31st, 2025 in Lake County, Ohio, the defendant, Christian McLean, did an act without privilege to do so and with purpose to prevent, obstruct, or delay the performance by a public official of any authorized act within his official capacity that hampered or impeded the public official in the performance of his lawful duties. Now, the following words contained in the charge set forth in count 2 are defined as set forth below. Privilege means an immunity, license, or right conferred by law or bestowed by express or implied grant, or arising out of status, position, office, or relationship, or growing out of necessity. A person acts purposely when it is a specific intention to cause a certain result. The defendant acts with purpose if at the time in question it was present in the mind of the defendant a specific intention to prevent, obstruct, or delay the performance by a public official of any authorized act within the public official's capacity. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to him unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all other facts and circumstances and evidence. In determining the existence of the mental state purpose, proof of motive is not required. The presence or absence of motive is one of the presence or absence of motive is one of the circumstances bearing upon purpose. Where an act is a crime, a good motive or purpose is not a defense. Voluntary intoxication may not be taken into consideration in determining the existence of a mental state that's an element of a criminal offense. Voluntary intoxication does not relieve a person of a duty to act if failure to act constitutes a criminal offense. However, evidence that a person was voluntarily intoxicated may be admissible to show whether or not the person was physically capable of performing the acts with which the person is charged. Public official means any elected or appointed officer or employee or agent of the state or any political subdivision thereof, whether in a temporary or permanent capacity, and including without limitation law enforcement officers. To hamper or impede means to do some affirmative act that disrupts, hinders, or stops the progress of the public official. Lawful duties means any act or acts that a public official is required by law to perform or is permitted by law to perform in good faith. Now, in count 3, the defendant is charged with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about August 31st, 2025, in Lake County, Ohio, the defendant, Christian McLean, operated a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. The following words contained in the charge set forth in count 3 are defined as set forth below. Operate means to cause or have caused movement of a vehicle. Vehicle means every device in, upon, or by which any person or property may be transported or drawn upon a highway, except that vehicle does not include any motorized wheelchair, any electric personal assistive mobility device, and then any device that is moved by power collected from overhead electric trolley wires, or that is used exclusively upon stationary rails or tracks, or any device other than a bicycle that is moved by human power. Alcohol means ethyl alcohol, whether rectified or diluted with water or not, whatever its origin may be, and includes synthetic ethyl alcohol. Alcohol does not include denatured alcohol and wood alcohol. Under the influence means that the defendant consumed some alcohol and or drug of abuse and or combination of alcohol and a drug of abuse, whether mild or potent in such a quantity, whether small or great, that it adversely affected and noticeably impaired the defendant's actions, reaction, or mental processes under the circumstances then existing and deprived the defendant of that clearness of intellect and control of himself which he would have otherwise possessed. The question is not how much alcohol and or drug of abuse and or combination of alcohol and a drug of abuse would affect an ordinary person. The question is what effect did any alcohol and or drug of abuse and or combination of alcohol and a drug of abuse consumed by the defendant have on him at the time and place involved. If the consumption of alcohol and or a drug of abuse and or combination of alcohol and a drug of abuse so affected the nervous system, brain, or muscles of the defendant so as to impair to a noticeable degree his ability to operate the vehicle, then the defendant was under the influence. Now in count 4, the defendant is charged with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. Before you can find the defendant guilty of this offense, you must find beyond a reasonable doubt that on or about August 31st, 2025 in Lake County, Ohio, the defendant, Christian McLean, having previously been convicted of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them within 20 years of this offense date, and again that's August 31st, 2025, operated a vehicle while under the influence of alcohol, a drug of abuse, or combination or combined influence of alcohol and a drug of abuse, and after being arrested for this charge was asked by a law enforcement officer to submit to a chemical test of his breath, and after being advised by the officer in accordance with the law of the consequences of his refusal or submission to the test, refused to submit to the test. Now, the following words contained in this charge set forth in count 4, defined as set forth below. The terms operate, vehicle, alcohol, and under the influence have previously been defined for you under count 3, and you're to use those definitions and instructions in considering this charge in count 4. Law enforcement officer includes a municipal police officer. Chemical test means a chemical test of the person's whole blood, blood serum or plasma, breath, or urine to determine the alcohol, drug, or alcohol and drug content of the person's whole blood, blood serum, or plasma, breath, or urine. The law enforcement agency by which the officer is employed shall designate which test or tests will be administered. A person is advised of the consequences of his refusal to take a chemical test when he is shown in read or written form prescribed by the registrar of motor vehicles advising him of the consequences of refusing to submit to the test. It need not be shown that the person subjectively understood the consequences of his refusal. A refusal to submit to a chemical test will occur when a person, by his acts, words, or general conduct, manifests an unwillingness to submit to the test. Such refusal need not have been knowingly or intentionally made. Previously convicted of an OVI offense within 20 years means convicted of the OVI offense, and OVI means operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It means convicted of that offense within 20 years before the date that this offense occurred in count 4. Refusal to submit to a test. As to both counts 3 and 4, evidence has been introduced indicating the defendant was asked but refused to submit to a chemical test of his breath to determine the amount of alcohol, a drug of abuse, and or a combination of alcohol and a drug of abuse in his system for the purpose of suggesting that the defendant believed he was under the influence of alcohol, a drug of abuse, and or a combination of alcohol and a drug of abuse. If you find the defendant refused to submit to said test, you may, but are not required to, consider this evidence along with all the other facts and circumstances in evidence in deciding whether the defendant was under the influence of alcohol, a drug of abuse, and or a combination of alcohol and a drug of abuse. Now, as you will note, it's alleged the offense's charge took place on or about August 31st, 2025. It is not necessary that the state prove that the offense was committed on the exact date as charged in the indictment. It is sufficient to prove that the offenses took place on a date reasonably near the dates claimed. It is also alleged that the offense charged took place in Lake County, Ohio, before you can decide whether whether the state of Ohio has proved beyond a reasonable doubt all the essential elements of the offense with which the defendant is charged. You must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense was committed in Lake County, Ohio. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to the other count. The defendant may be found guilty or not guilty of one or all of the offenses charged. If you find the state proved beyond a reasonable doubt all the essential elements of one or more of the offenses charged in the separate counts in the indictment, then your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of one or more of the offenses charged in separate counts in the indictment, then your verdict must be not guilty as to such offense or offenses according to your findings. Now, additional findings. If your verdict's guilty to failure to comply with an order or signal of a police officer as charged in count 1, you will then separately determine whether the state has proved beyond a reasonable doubt that the defendant's operation of the motor vehicle caused a substantial risk of serious physical harm to persons or property. If your verdict is not guilty to count 1, you will not decide this issue. If your verdict is guilty to obstructing official business as charged in count 2, you will separately determine whether the state has proved beyond a reasonable doubt that this violation created a risk of physical harm to any person. If your verdict is not guilty to count 2, you will not decide this issue. Now, the following words contained in the additional findings for counts 1 and 2 are defined as set forth below. Cause. The state charges that the defendant's operation of the motor vehicle caused a substantial risk of serious physical harm to persons and or property. Cause is an act or failure to act to which a natural and continuous sequence directly produces the substantial risk of serious physical harm to persons and or property, and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in an ordinary course of events from the act or failure to act. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain or particular result may occur or that a certain or particular circumstances may exist. Serious physical harm to persons means any of the following: any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment, any physical harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Physical harm to a person means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Serious physical harm to property means any physical harm to property that does either of the following: results in substantial loss of the value of the property or requires a substantial amount of time, effort, or money to repair or replace, temporarily prevents the use or enjoyment of the property or substantially interferes with its use or enjoyment for an extended period of time. Physical harm to property means any tangible or intangible damage to property that, in any degree, results in loss to its value or interferes with its use or enjoyment. Physical harm to property does not include wear and tear occasioned by normal use. Risk means a significant possibility as contrasted with a remote possibility that a certain result may occur or that certain circumstances may exist. All right. So that concludes my instructions at this point. Again, I'm going to give you some final instructions on how to conduct your deliberations, but we'll do that after closing arguments. So we're going to proceed to closing arguments at this time. Let me remind you that what the attorneys say is not evidence, but closing arguments are an opportunity for each side to summarize for you what they believe the evidence in the case is established. The state of Ohio, having the burden of proof, gets the opportunity to go first. The defendant then has an opportunity to make a closing argument. And then the state of Ohio, because they do have the burden of proof, gets the opportunity to make what we call a rebuttal argument. So for the state of Ohio, Ms. Linden. That's it.
Ladies and gentlemen, you've heard evidence over the last 2 days. What I'd like to do, I know that in the judge reading all of that to you, it's a lot of words, a lot of information. You will have that to take a look at, but I'd like to just talk with you about each of these charges and what the state, at this point in time, would ask you to consider. When we're talking about failure to comply with the order or signal of a police officer. I want to first go to the things that are not in dispute. Who? It's the defendant, it's not anybody else, not a whodunit. What happened? He was driving a motor vehicle. You saw that, he's in the car, he drove it. He fled from the police. You watched the video, that's what he did. He did not exit the vehicle, not the first time, second time, third time, fourth time, fifth time, sixth time, didn't get out. That he drove way at a high rate of speed, you can see that as well. That several officers chased the defendant with lights and sirens. That this happened in Lake County, Ohio, and that this happened on or about the 31st day of August at approximately 2 a.m. on a Sunday. So those are things that are not in dispute. So when we look at failure to comply with the order or signal of a police officer, one of the things you have to look at is, here, did he willfully elude these officers? Did he willfully drive away? I think one of the most important things to look at is the fact that you heard Officer Jones say, I stood there and I watched him put it in gear. He made that decision with the officers there, plenty of police cars, plenty of police officers around him. His choice was to leave. Here, in terms of looking at, did he receive a visible or audible signal from a police officer? I don't think you can get any more visible or audible than 3 cars with flashing lights, sirens, the fact that you have a police, the fact that you have other officers on the roadway as you're driving as well. It's pretty clear that there was a visible or audible signal from a police officer and that he was supposed to stop the vehicle. Here, the issue will be, and I'm sure that Mr. Langman will touch on this, is there a substantial risk of serious physical harm to persons or property? I would submit to you that when you're looking at that, look at and listen to, again, if you need to, on those videos, the testimony and what you're seeing and what you're hearing. You have a defendant who has initially not driven within the lanes as he's supposed to, and this originally draws Officer Muir's attention. So he's driving at a slow speed, kind of weaving in, coming very close to that semi as he's getting onto the roadway. Almost looks like as he's driving he's going to get off at that exit, but he doesn't. The officer hasn't turned on his lights at that point in time, but either the defendant knew that the police officer was there and he needed to get over and he was going to put his lights on, or he needed a good place to eat, I don't know, but the place that he chose, and the fact that it's right near that exit, and you can watch the video. You know, I know Mr. Leonard started opening, but watch the video. I encourage that too. If you watch, what you can see is several cars actually have to kind of slow down and almost brake to try and get around him so they can get off at the exit. You have the fact that you have 3 officers, and at one point 4 officers, and the demonstration was kind of the area that we have, that you have the vehicle, and you have 1 officer at the front of the vehicle, 1 officer back here, and then it only goes to about here. So you're talking about this much room and a guardrail. And if you watch the video, you can see that Terminator stick flip out and go onto the side of the roadway. And at that point in time, there's an issue with the defendant's tires. And this is where, when we talk about reason and common sense, use your reason and common sense to think about the fact that when you have a tire that's deflated like that, something that's ripped from the back of your car, and you're taking off and going 100 miles an hour, is there a substantial risk to persons or property? I would submit to you, even to the police officers, there's a risk. While they're standing there, there's a risk to Officer Muir talked about the fact that there are pieces of this tire shredding off as he's going. You can see when you watch the video, there's smoke coming out at some point in time where he's riding on the rim. Any wrong move, and it's going to be an even more serious issue. But this officer, you've heard testify, had to move out of the way, move lanes out of the way just to get out of the debris. At this point in time, there is not as much traffic. Why? Because there are 3 officers who have basically blocked the roadway so that no one else behind can come forward and risk being injured, risk any kind of a crash, risk any kind of injury. Why block off an entire roadway if there's not a substantial risk of serious physical harm to persons or property? The whole roadway blocked off. Why do you have other officers being involved? Why do you have them calling ahead, trying to get stop sticks, trying to get this person to stop? I would submit to you part of it is because of some of those initial observations of Officer Meerkat, the original slow speed weaving, and then the fact that he could tell there was a smell of alcohol. And that if you listen to even the discussion that he has with Officer Jones on the body cam, he says, well, he's highly intoxicated. You can watch the defendant's movements, and they're kind of slow and deliberate while he's talking to him. And I know at one point in time, Officer Meir says, well, he's kind of even smart ass. Well, you have somebody who is, you're asking him a question. Where are you coming from? Simple question, where are you coming from? Response, well, where are you coming from? So he doesn't even want to answer simple questions like that. And I know I've made an issue about this whole thing with the Chick-fil-A, but you're using your reason and common sense. You have somebody who's pulled over. You have an officer who's there talking to you. He basically is like not answering questions, but just kind of doing what he wants to do, and quite frankly being somewhat disrespectful in doing that. But also, why would you do that? Maybe because you're impaired. Here, with the smell of chicken, maybe you're trying to mask the smell of the alcohol. And I would say to you that that's part of, I think, what's going on here, because if you look at the fact that the window is halfway down, and he's talking to, the officer's talking to the defendant, window's halfway down, he's talking to him, says he can smell that, then he asks him, how much have you had to drink tonight? Well, the next time an officer comes up and the defendant doesn't even realize that the second officer is not the one who pulled him over, and I would submit to you, if you look at Officer Jones and you look at Officer Muir, they don't look alike. The fact that he's doing that, and the window's only this far down, why do you think the reason is for that? Use your reason and common sense. Somebody's after you, you're drinking, you're eating your chicken, but you're thinking maybe they smell the alcohol, they're going to put out the window and try and avoid that again. So here, looking at all those things, looking at the fact you have an impaired driver who's driving down I-90. There's a lot of cars on that roadway. There are a lot of trucks that take that. And even at 2 in the morning, if you watch those videos, there's car after car after car after car. So it's not only a substantial risk of serious physical harm to these officers, their patrol cars, but also those individuals that are in the roadway. Here, what did the defendant do? First of all, there's the dark window tint. So it does make it hard for the officer to see what's going on inside the car, and that's an observation of the officer. And he's erratic driving. He's back and forth over the center line. You can see even when the defendant takes off, if you watch the video. Now, it's not, and I know that the question was asked about jerking. It's not a this, it's, you realize you're kind of going over and you're pulling yourself back. And this is all speeds of 100 miles an hour, 80 miles an hour, 100 miles an hour, and then down after that. He chooses that odd place to stop, doesn't even realize that the officer is there at first. There's the odor of alcohol. He's asking the officer the same questions. His speech is slurred and somewhat nonsensical at that point in time. He has bloodshot eyes, slow movements, and he appears to be impaired. So there's evidence that you've been shown, and you can see the photos of the window tint meter, and that's one of the reasons for the stop. And you'll have an opportunity to look at the photo of the vehicle. And one of the things that the big question is asked about, well, why does he have to get out of the vehicle? When a police officer has stopped you for a traffic offense, he is permitted by law to ask you to exit the vehicle. Now, I understand that Mr. Langbeck said in his opening, well, some people don't understand that. I would submit to you that based on the number of times that he was asked to get out of the vehicle and told to get out of the vehicle, and failed to comply in doing that, he knew he needed to get out. When he realized that they were going to pull him out, he decided to take off. He made that conscious choice to do that. Other thing I'd like you to look at is the map that we have here. This is not a short distance that he decides to go on this high-speed chase. He starts out in this particular area here, in the I-91, so he's there, and he takes these officers that entire way. So I would ask you to think about that too, the distance of this pursuit. It's well over 10 miles. It's a long way to go to not stop for the police officers. So look at that, and the fact that this is actually where he ends up stopping. And he doesn't stop of his own volition either, I will say that. When you have 3 tires that are blown, 1 rim, not going to go much farther. And you can hear on the body cam where the officer's talking about the fact, well, I don't think he's going to go much farther because of what they're observing. So the officer had that terminator. And you look at the photo, and you look at the back of that vehicle, what do you see? That bumper is almost all the way off. Okay, yes, we can look at this and say, thankfully, no one was seriously injured. There was no serious injury to property. Well, maybe to the car, but when we look at that, we can't say, oh, because it didn't happen, it wasn't a substantial risk. You saw that bumper in the video, and the bumper is going back forth. It almost looks like there's a blinker on because it's flapping around and pieces of that tire are coming off. And then looking at where the officers are, whether or not there's a substantial risk to these officers, they have to back away. In that small area that they have to back away to avoid any kind of injury. So the officers are there by the guardrail, and then the defendant flees right where the vehicles are exiting. You can actually see in the number, and you can see even in the bottom right photo, you can see that there are vehicles right on the roadway. He goes right towards those vehicles that are on the roadway. This is right by that exit. And I would submit to you that speed alone, going 100 miles an hour as it is, that's a substantial risk of serious physical harm to persons or property. Going 100 miles an hour impaired, even more so. Going 100 miles an hour impaired and also having a shredded tire and riding on your rim, even more so. I would also submit to you that here, if you look at a change in the way that the dotted lines are, it's very clear that where he is and where he's leaving is right where you're getting off to go into that exit. There's a difference in the way the dotted lines are because that's right before that exit. And you can see the traffic on the roadway, and you can see the time frame here just even after he's already taken off. It's 2:24:27, and it goes at least until 2:32:57, a little bit more even after that. The obstructing official business. When we're looking at the charges here, I would submit to you that that's actually really what happened first. What happened first was he was pulled over for a traffic violation. The fact that he continuously refused to get out of the car, continuously refused to submit to a lawful order. He delayed and delayed and delayed and delayed and delayed and didn't want to get out of the car. And we're talking for a period of like almost 10 minutes that he's not complying with the officers, and then ultimately when he takes off, you have to look at the fact that these officers are performing an authorized act. They're doing their official duties, and did this here hamper that or impede that at all? They can't get him out of the car and do field sobriety tests. They can't get him out of the car at all to further their investigation to do that. That's by the defendant's choice. He chose not to do that. And then, does that present any kind of a risk? One of the things that you heard Officer Muir say is that, could have gotten my foot run over, any of those things could have happened. So is it a risk of physical harm? Yes, absolutely. Okay, and here where you're looking at the fact that the defendant is talking to Officer Jones window's not really down, he's not really paying attention. Instead of really listening to what the officer has to say, who has you pulled over, who has their lights on, while you're on the side of the road, you're talking on the phone to your mom. Not what you would normally see. And here again, just showing where these officers are, how close they are to the guardrail, and the fact that they have to actually get back. Is when the officers go to breach the car and get him out of the car, he realizes, oh no, they're really coming in. I'm not going to let that happen, and he takes off. We then have the operating the vehicle under the influence. So is he under the influence? And you saw up on the screen, and you'll have with you the definition of what that means. It doesn't mean you're drunk as a skunk. Are you under the influence? Look at what the officer observed. Look at the video as to the defendant's driving initially, and then look at the way that the defendant responds, his mannerisms. You heard that Officer Mir said that he had a bloodshot and glassy eyes at that point in time. If you watch the way that he's like fumbling around to try and get his insurance card, but that's kind of right around the same time that he's doing that, and the time that he's been asked about the alcohol, that's when he's going to do something different and get his mom on the phone. So when you look at that, did he operate the vehicle? Yes. Was he under the influence? Based on the facts and circumstances and based on what you can observe with the defendant and what he says? Absolutely. And here, there's a stipulation to the fact that he has that prior conviction within the last 20 years, and that's what you would consider for this particular charge. When you have that prior conviction, you have to be notified of the fact that there are consequences. And here, Officer here talked to you about the fact that he read that form to the defendant. He told the defendant of the consequences for the refusal, asked the defendant to submit to that breath test, and he refused. So when you're looking at the way that the car looks in the end, when you're looking at some of the evidence that you can see in the photos, when you see some of the things that you see in the car that are located, and one being just behind where the passenger's seat is, there's that issue of there being alcohol in the vehicle as well. Did he drink it right then? He's not drinking it as the officer pulls him over, but it is in the vehicle and it is something to consider. So what did Officer Mir testify to? His extensive training on drug and alcohol impairment, his observations of hundreds of traffic stops in his career. It basically said that it's vital for people to get people off the road. So if you have an impaired driver, it's not somebody that you want to continue on the roadway, and they have a duty for the safety of the community and for their safety to get that person off the road. Time of the day doesn't matter. It depends on a lot of factors: speed, intoxication, other cars, traffic. Doesn't matter if it's day or night. If you're impaired, you're driving, there are other people on the roadway, are you a substantial risk? Absolutely. Here, defendant was impaired, slow speed, driving, that initial driving. You see that he's close to that semi on the 90 ramp, but then you also see when there's another semi going down the roadway that he swerves kind of towards the vehicle, has to go back, and then has to go around that truck. Here, you have to look at the defendant's behavior too, the traffic violations, the weaving, the riding the center line, the tinted windows, the failing to signal when he's changing lanes. That's another thing that was discussed. When he's going back and forth between these lanes, he's not signaling either. Speaking to the defendant, doesn't even notice that he's there, more concerned about his chicken, the odor that he sees, and then, or odor that he smells, those bloodshot eyes, the slow movements, as I talked about, repeating the questions. Rather than talking to the officer, he wants to talk to mom, and then multiple times. There's at least 10 times that he asks him to comply, and he does not. So you'll see these things when you look at the dash cam, and I just ask you to consider each of these items, and you have to look at also the force that it had to take for that Terminator stick to hit the tire the way that it did, and if you watch the way that it flies out, it's clear that it's a very high rate of speed that he's leaving and fleeing. And when he's pulling out, he doesn't usably pull out, and like I said, if you watch, there are cars going by on the ramp there, and he's lucky that no one else came through at that point in time. So in terms of those factors that I've talked to you about, and the fact that the tire, parts of the tire are even flying off, those are things I would ask you to consider. These are other items, like the swerving around the semi that I talked to you about. So these are all things to consider when you're looking at that. It's not just one thing, it's a lot. So why did the defendant act this way? Just ask you to use your reason and common sense. Why do you flee a scene? Why won't you get out of a car? I would submit to you because you're impaired. You know you're impaired. And you know that as a result of that, you're going to be arrested. We would ask that you find that you're closed today, defendant guilty of all those charges that have been submitted to you. And I thank you for your time and your attention.
Thank you, Ms. Linden. Mr. Lamack for the defendant.
Morning, Inspector. I don't know if he was lucky that he pulled out, or even more than I'm lucky that when I stop at the stop sign and go again, I'm lucky a semi doesn't plow into me. Except I'm looking to see that there's no semi. Well, it's not luck. Let's see. Obviously, 4 different charges to talk about here. Let's address the alcohol first. We heard that there was an odor of alcohol from the vehicle. No testimony ever about it coming from Mr. McLean as he was out of the vehicle. At some point, he was out of the vehicle. We saw him walking back. He's up, walked towards him. He testified to how he smelled. So, is there something in his car, or is there something in him? No testimony to while he's being booked in at the jail, while they're talking to him. Oh yeah, it's 100%. There's booze. I'm smelling booze on Mr. McLean. Yeah, in your hand. No beer smell, no booze smell, no anything. Just while he's sitting in the car, there's an odor coming from his car. That, and of course, the infamous Chick-fil-A. Which, despite being cold, is still apparently very, very pungent. And now, as I have learned, is a good way of masking the odor of alcohol. You just got to keep a bag of Chick-fil-A in your car. If you've been drinking, start chowing on that, they'll never know. I don't know. Seems ridiculous to me, but it's been offered. We've seen no pictures of his glassy or bloodshot eyes. Well, he disappeared. You have him in custody. Take pictures. Why didn't we see these infamous bloodshot and glassy eyes? Curiosity. Apparently it was easy to see his eyes while he's sitting in the vehicle. Very clear, bloodshot and glassy, but it's hard to see anything else. He certainly crossed over the striped lines, as we saw in the video, while he's making that curve behind the semi, going from 90 to 271 split to continuing on 90 eastbound. He certainly saw that. And swerving is a new favorite word, apparently. I don't know if we're getting bonus points for saying it many times, but I don't think I ever saw a swerve on the video at any point, before or after. Certainly some concerns about maintaining his lanes before the stop, but that's not an issue. No citation, no charge for that. The jerking as well. I think I played that a few times, rewinded a few times. Like, all right, show me where the jerking is. It's all up on that big screen for us to watch. Okay, here, it was right there. I missed it. Let's go back. Did it over and over again. You guys saw the same that I saw. I didn't see any jerking. Matter of fact, it seemed that he maintained pretty reasonable control of his vehicle. Certainly, going 100 miles an hour, not acceptable. I'm not here to tell you that it is, because it's not. Drunk, not drunk, stone sober, never had a drop of drink in your life, you don't go 100 miles an hour. That's a problem. You can't do it. It's not a good idea. But, despite his high speed, and no back right tire, he's not fishing. He's not swerving. Not swerving in his lane. Not cutting people off. Despite a car here, a car there, and a car there. We saw the cars. You can see it. You can watch the video. He's not cutting anybody off. Nobody's swerving to get out of his way. He's not acting erratically. He's driving fast. Once again, no problem. But he's driving fast. He's not creating a risk to anybody else in the highway any more than anyone else driving quickly. But here, part of the issue in the failure to comply is a substantial risk. Substantial risk, you'll actually have this with you in the jury instructions. Substantial risk, and I know I told you before when we started, means a strong possibility, as contrasted with a remote or even significant possibility. So we're talking more than significant possibility. That a certain particular result may occur or that a certain or particular circumstances may exist. So substantial doesn't mean this could happen. Yeah, I think it might. That's not substantial. That's remote, or maybe even significant. This is beyond significant. I submit to you that I'm not even sure there's a significant risk of serious physical harm to people or to property at any point during his driving, any more than anyone else driving. Didn't lose control. You've seen the video, you watch it again. Where is that substantial risk? Substantial risk. You know, the tendency might be like, oh, come on, he was driving fast. They said he was drunk. They can say anything they want. You can watch the video. At what point was he all over the road? At what point was he a risk, substantial risk, to anybody driving there? Then they blocked it off, and there's nobody around. Now, they showed the picture at the end there of his car, his tire. Yeah, that's gone. His bumper, that's torn up. It's not illegal to damage your own property. You can't break into your own house. There's no burglary in your own house. You can do whatever you want. You can take your TV, throw it out the second floor window of your house. That's not illegal. It's not very smart, but it's not illegal. Him wrecking his car, doing whatever he wants to his car, not illegal. As for when Mr. McLean took off, he was scared that the police meant to do him harm.
Sustained.
All right. We heard him say that the police were going to kill him twice. That's what we heard. I have no doubt that none of these officers meant to ever harm him. No doubt at all. Not one moment that I'm thinking, uh-oh, he's in trouble. Not. I don't know whether to blame the overhyped media in pushing this narrative or society in general. Nonetheless, that narrative exists. I personally vehemently disagree with it. Vehemently disagree with it. But it's out there. To dismiss it out of hand is just not proper. At some point, in the video, we saw the dash cam. As we saw the dash cam, it was at 2 hours or 2 o'clock, 23 minutes and 20 seconds in. You saw Officer McNamara take his gun out, take it out of his holster and hold it at the high ready, as was described by Officer Meary. And at the high ready up here, he's in front of the police car behind Mr. McLean's car. Blocking, as was admitted, blocking, and you could see the spotlight. So what the spotlight's doing is it's silhouetting the officer behind Mr. McLean. Now, the rearview mirror looks backwards. Potentially, Mr. McLean can see in the mirror there is now a police officer behind him with a gun in the air.
Objection.
Sustain.
Shortly after, the gun is taken out and held at shoulder, head level, behind Mr. McLean's vehicle. That's when Mr. McLean puts the car in drive. That's when everybody kind of takes a step back and stands there. Okay, go on, take off. You're gonna get a million more charges. And Mr. McLean drives off. I'm not telling you he was given permission to leave by that. We all heard what was said. Mr. McLean drives off. Coincidence that the gun comes out and he drives off 5, 6 seconds later? You're the jury. But also, when they drive off, a lot has been made about, we got the car here, the cops here, the guardrail there. Uh-oh, we're trapped in here. Uh-oh, what are we going to do? Danger zone. As I asked, and as you saw, and as you can see it again, none of those officers looked like they were in any fear of anything. Right, they were laughing. Kind of saying, like, huh, some gun, look at that. Holy cow. What a guys. Well, with these guys, with the hundreds and 30 to 50 chases, I think the odds are always pretty good that there's going to be a chase. Never heard of that man. He takes off. A little bit more is made of the Terminator stick that we were told by Mr. Muir. Mr. McLean had no idea it was there. It was kind of snuck up slowly and put it under there and crept up slowly. That was the whole purpose of doing that. Something's being made of this Terminator stick, potentially being a danger to them. Oh, what could happen? You know, who knows? Well, we've heard testimony. These guys have employed this many times. They've seen it happen. They know what happens. Does it always work? No. But they know what it does, what it could possibly do. They've been trained for this. So they know where to stand, where not to stand. Just like you know not to stand in front of a car that's going forward. That's common sense. This is extra training. We're told not to do that. They know where to stand. That's why they stood where they stood. When I asked Officer Jones, was there any possibility that he could have hit you with his car? He said, no. And you'll see where he was the furthermost towards the front of the car. There's just no possibility. Mr. McLean pulled straight away into the roadway and kept on going. At no point were any of these officers in danger of being struck by Mr. McLean's vehicle. Once again, we get to his driving after the fact. I mean, we hear the swerving again. He's swerving again. He's changing lanes. I mean, how many times am I swerving when I'm driving? A lot more than I thought. He's just changing lanes. You can see it. He's not jumping over real fast. He's just moving over from lane to lane. He's not cutting anybody off, not ramming anybody, not shoving somebody off the road. He's not tossing anything out of the vehicle that we can see, that anybody testified to, trying to get somebody else out of his way. He's just driving. He's driving quickly. Could that even be considered significant risk? I don't know. I've seen people pass other people. I've never looked at that like, oh man, that guy could kill somebody. When that guy's broke. You're just passing somebody. When you pass somebody, you go faster than them. Once again, 100 miles an hour, not acceptable. I'm not telling you that. I'm not suggesting that. But we're not talking about that aspect of it. Going 100, improper. Going 100 is not a substantial risk. And he's also got that back right tire flat. Well, that does make it a little tricky. Because that does cause an issue. Because driving with 4 tires is obviously a lot easier to control than driving with 3 tires. And yet, driving with 3 tires didn't seem that hard to control. So we didn't see anything at any point where he was losing control. No fishtailing, no running off the road, might have been a little hard to maintain a straight line. But he's not cutting people off. He's not going lane to lane to lane, back and forth, all the way to the left, all the way to the right. Driving pretty darn well. 3 tires. I'll admit, I haven't done that, so I can't tell you from experience, but I imagine not many people have. get a flat tire, you generally stop. Which is obviously a different scenario. There's a difference in understanding why he had to exit the car and not understanding the words being said. I don't think anybody's trying to suggest that he didn't understand the words or what somebody was saying. It seemed like they were conversing to a degree. Maybe not all the answers that the officer wanted. Maybe some smart alecky stuff on both sides. A little snarky. It happens. But he understood what he was saying. He didn't understand why. Why do I have to get out of the car? Once again, there are people that don't think they have to get out of the car. Short and sweet of it is you do. The Supreme Court law says you do. But not everyone is well versed, as I am, and some other people. That's what we do. Not excusing it. He should have exited the vehicle, but he didn't. He wanted to know why. He didn't feel he did anything wrong. Extending the stop, obstructing it, not listening. It's 10 minutes from the moment he's pulled over or the moment he pulls away. And a lot of that was extended by Officer Jones because he's waiting for more people. He was in no hurry. He's going to say, come on, hurry up, hurry up, hurry up. He's like, you know, let's just relax. I'm kind of letting him talk to his mom on the phone. I'm here, but I'm just watching. No big deal. He's in no hurry. And during this obstructing, where was the risk of physical harm to the officers? I mean, it certainly wasn't with the vehicle. We've already said, we've had testimony that nobody was hit, nobody was even in danger of being hit. Okay? Officer Jones says, no, I couldn't have been hit. Not even if he had cranked that wheel all the way to the right before he moved and then hit it, he's still not going to get him. He'll drive into the guardrail, but he's not hitting one of the officers. The officers know where to stand. That's their job. They know what they're doing. They stand back, so they're not going to be in harm's way. During this obstruction, during the stop, while he's sitting there, I didn't see anything that said, oh yeah, I was at risk of danger there. There were no weapons found in the car. There were no weapons threatened by Mr. McLean. He didn't have anything. He didn't say, I'm going to get out of this car and beat you up, or I'm going to shoot you, stab you. You can't talk to me like that. I'll find you. There's nothing. There's not even a threat of harm to the officers. I don't know where we find the created risk of physical harm to the officers when no one has said that they were ever in any danger while he was sitting there on the roadway. And I don't think anybody said they were in any danger while they're following him on the highway afterwards. There were little bits of rubber coming off, for certain. We saw the tire, the flat part of the tire, an expert, roll off to the side, kind of slowly, went off into the median area. And there were some little bits that were coming off. And I think Mr. Officer Meir said that. He's like, oh, little bits coming off. He was even scared, oh, what if one comes up and cracks my windshield? Well, his worry was, then I'll have to stop the pursuit. All right. Not, oh man, that could hurt me. I could crack my windshield, I'll go off the road, who knows what could happen. He's like, well, if that happens, I have to stop the pursuit. That was the concern. Not for safety. I'm not going to stop this pursuit. I'm not going to do anything that's going to let that happen. I'm keep going. I got over 200. I'm just padding those numbers.
Sustain.
Ladies and gentlemen, we've had a lot of embellishments during the testimony. For some reason, leaving the blinker on for a few minutes is a big deal. Okay? Chick-fil-A. Much bigger deal than I ever would have thought would be in this case. The animated hands. You can see his hands. It's like this, talking. I might even be as animated as him. Animated hands. I don't understand the concern. And a lot about this proximity to the exit on 91. I mean, Well, from Lake County, I'm sure we've driven there. We know where that is. We know this, and we can see the pictures where they are and where the exit is. I didn't see anything that gave me alarm or cause for concern on any of the traffic going by that was getting off, nor looking at that, where they were stopped, why I would even care about that. And they're like, oh, he pulled over at a bad spot for us. Well, you gotta mark these good spots better, I guess, if somebody wants to pull over. I mean, it's just, they pull over. I mean, it's just where it is. Not with the intent, well, who knows the intention, but I don't see any, I don't get it. Who cares about the exit? It's 2 in the morning on a Sunday. We're not talking Friday at 5 o'clock, everybody's going, getting out of going home, and now it's busy. As was testified on the stand earlier, there's a big difference, huge difference. Initially, there's little difference. But eventually, it was admitted, there's a huge difference in daytime rush hour traffic and 2 in the morning on Sunday. I think we all know that. That's obvious to everybody. There is not so much traffic that anybody could have gotten off that highway at exit at Route 91 without any difficulty. And then we get the stop lasting longer than usual. Oh man, it went forever. Half of that was them stone. And then the other ones, well, there are many businesses in the area. A lot of people around there. Many businesses in the area. Traffic. On the highway. Where's the business? Is there some kind of a hot dog cart over there by the bridge that I don't know about? I mean, yeah, there's a Sheetz if you get off the highway and head north. Yeah, sure, there's a car dealership. If you head south on 91, pretty sure 2:30 in the morning they're closed. You're not going to be digging and walking around there. I just, a lot of things were brought up in this that just didn't make sense, just to embellish on things. What's the point? Just say what it is. You know, if we're talking about A, B, and C, talk about A, B, and C. Not that, you know, the shade of B or the color of C or how bright it was with A. When you start embellishing things, it makes you wonder what else you're embellishing. What else are you talking about that maybe isn't quite what you say, but, you know, we can make that fit. We can make it seem like something it isn't. I think that's what we have here. I think that's what we have here. We have Mr. McLean pulled over, doesn't understand why. Took off. Saw a gun. There's a gun raised.
Sustained. That's stricken.
We do not. All we can see is what we can see. You can see it, you can hear it, you've seen it and heard it. Please see it and hear it again if you have any questions about it. But as far as the alcohol, smelled something, saw some glassy eyes. At one point, no follow-up on that. No, you got him on the car. Where is it? Where's the picture? Show me his eyes. There's the picture. Well, look at those eyes. Those are red as all get out. And glassy as the sun of the gun. We don't have that. I don't. Nobody has a camera anymore? 8-year-old has a camera. Take a picture. Show me the picture. You're saying this is what it is? Show me that picture. Show it to me. And have it. Listen to everything. Discuss it. Pay attention to every part of it. Not just what one guy says, the other guy says, what did they say that was the same, what did they say that was different. Consider everything. And then use your common sense, and use your reasonableness, and come to the conclusion, we have no actual evidence of intoxication. We have no actual evidence of impairment. A lot or a little. We have an odor, and we have supposed glassy eyes, bloodshot eyes. And as far as his driving, driving, going at a rate of speed, with one flat tire, seemed pretty darn good. Not impaired. Seemed pretty darn good. Consider that. Look at the totality of it. Not just when he was crossing over the stripe lines before the stop, but afterwards. Seemingly under a little bit more pressure. How was that driving? And was there substantial risk? I know it's that vague terms like beyond a reasonable doubt. Substantial, but we know it's more than remote, and it's more than significant. Substantial risk of serious physical harm to persons or property. We think once you do that, you're going to come back with that. We're not saying nothing happened. We're just saying it's not discharged.
Thank you. Ms. Linden for the state.
Thank you, Your Honor. Mr. Langmack used the term several times, embellish. I'd ask you to go back and think about the testimony of both of the officers and the fact that they told you what happened. They told you the facts of the case. Mr. Langmack stands up here and wants to talk about things that weren't discussed or that didn't happen. And then uses the word embellish again. I submit to you if anybody's embellishing about what he thinks happened, it would be Mr. Langmack, not the officers. The officers told you what they saw, what they observed. These are out there who saw what happened. There's all these discussions about, oh, that McNamara got a gun out, and maybe, possibly, the defendant saw that. We don't know that. And what you can see is that before the defendant takes off, McNamara actually puts the gun down, puts it away. And I would submit to you that think about the fact that you have somebody who is on a traffic stop. You've been told multiple times to get out of the car. Either you don't think it's serious or you don't feel like doing it. If he did see a gun, that would be the time to be like, okay, time for me to get out. He didn't do that. So this embellishment is not something that was done by these officers. And it's in the video. I mean, they're consistent with what you see in that video. And it really doesn't matter here what Mr. Langmack gets or doesn't get. What matters is the facts that were presented, the evidence that was presented, and the way that you see that and the way that you evaluate that. Here, it's nighttime. And I would submit to you that when he said when you see somebody kind of go by, oh, they're going really fast. Well, I would submit to you, you watch the news and you see somebody who's on a high-speed chase, or you're driving on the road and there are a bunch of police officers on the roadway and there's a high-speed chase, your thought is, somebody's going to crash. Something bad's going to happen. This is not a good thing. So there's part of your substantial risk there. And I would submit to you, too, that you have an officer who's driving down the roadway with the smoke coming off the tire, and I would venture to guess that all of you have tires on your car. But we're not talking about little pieces of rubber. Those tires are meant to drive for a very long period of time. And tires are thick. And to think about the fact that that Terminator stick punctured it, but then as he's driving, and you can see it on the video, there are pieces coming off. And one of the things that Amir talked to you about was, I had to get out of the way. If one of those hits my windshield, I'm out of commission. We blocked off this roadway because there are pieces of this tire coming off. He could lose control at any point in time. There's a risk to anybody who even goes past. And I would submit to you, you can see how many cars would have gone past. When you look at the end of the video, you can see car after car after car after car that come after the roadway is finally reopened. I would also submit to you that you need to look at the fact that these officers have some significant training, and they're not just looking at one thing. They're not looking at two things. They're looking at the totality of everything that's happened from beginning to end. They're taking all that into consideration. And when you have an officer with the window down and he's standing at the window and you see him leaning in, he's leaning in the window, can he see your eyes? Can he see whether they're glassy or bloodshot? If you don't get out of the car, not much more you can see. And how do we know? When you have somebody who's gone on a high-speed chase, and it's for at least 10 minutes, we don't know what they're doing in the vehicle, we don't know what's happening there, we know nothing about what went on in that car until he finally decided, well, he didn't decide, until his car finally gave out. So Mr. Langmack would have you think that, okay, we need to take a photo after the fact, after all that stuff happened, to see whether his eyes are bloodshot or glassy. At that point in time, I would submit to you, there's so many other things that have happened, it's different from what the officer initially observed. And the defendant was given an opportunity to submit to a breath test. He refused. I would submit to you that that's significant. He was given that opportunity. Knew that there were consequences. Again, didn't want to do it. Kind of the story of the whole case. Defendant doesn't want to comply. One of the things that you heard from Officer Meir also was that they didn't know if another car would be coming off that roadway when the defendant got out, didn't know if they would be hit, that would hit there. They've seen cases where somebody's gone at a high rate of speed, somebody's had equipment issues or had impairment. All of those situations are situations where there's a substantial risk of serious physical harm. You're in a car. You're in a car. Is driving a car at a high rate of speed with a blown out tire, is that a substantial risk? I see some people every day who have trouble just driving regularly, let alone with that. And I'm sure that in some of your lives, you've seen individuals in car crashes, speed being a factor. You've seen individuals who have maybe been, something's a result of somebody who's an impaired driver. At any moment, those types of things can happen. And so in terms of looking at this, the fact that we don't have rush hour traffic doesn't matter. It doesn't say that in the revised code. What it says is substantial risk of serious physical harm to persons or property, or a risk of harm to persons. What I would submit to you finally is here, there's nothing in the record to say that these officers wanted to do any harm to this defendant. Quite the contrary. Officer Jones is more than patient with the defendant. That had to do with them being corrupt officers, but he was more than patient. And as he indicated to you, most other circumstances, he wouldn't have waited that long. Now, whether we like that or not, when we have individuals who are pulled over on the roadway, you could be asked to get out of the vehicle. And the defendant is the one who caused all of these events to occur afterwards. And I would submit to you that if you think to yourself, why? Why not comply? Why not get out of the car? Why, if you're asked about alcohol, do you then roll the window up? Why do you then take off? Well, I would submit to you because you're impaired and you know you're going to get arrested. So I would submit to you that based on those facts and circumstances and all the evidence that you've heard, that we're confident that you would look at the defendant guilty of the charges. Thank you.
Thank you. All right, ladies and gentlemen, we're going to pick up with the conclusion of my instructions at this point. Oops. There we go. The court has given you the instructions on the law applicable to this case. I will now instruct you on how to conduct your deliberations and prepare your verdict. When you go to the jury room, your first function will be to select one of the jurors to serve as a foreperson. The person you select as foreperson does not have any greater power, nor does that person's vote have any more importance than others. That person serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form is returned to the courtroom after you have reached a verdict. Once the foreperson is selected, you will commence your deliberations. Your initial conduct upon commencing deliberations is immense. It is not wise to immediately express a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused, and you may hesitate to change your position if you later decide you are not correct. You should consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with the other jurors. Do not hesitate to change your opinion if you are convinced that it is wrong or if the discussion persuades you that you should. You should not, however, surrender honest convictions to be congenial or to reach a verdict solely because of the opinion of other jurors. The verdict must represent the considered judgment of each juror. To reach a verdict, it is necessary to agree. Your verdict must be unanimous. Your verdict must be based solely on the evidence and on the law as I have given it to you in these instructions. Nothing I have said or done is intended to suggest what your verdict should be. That is entirely for you to decide. If you have a question during your deliberations, it should be discussed in the privacy of your jury room. It should be reduced to writing, noting the date and time in the question, so there will be no misunderstanding as to what you request, and it should then be signed by the foreperson. It should then be delivered to the bailiff who will submit it to the court. Your question should not reflect the status of your deliberations. Please be patient in waiting for a response because the judge must consult with the lawyers for the parties before sending his response. The court will then attempt to answer the question as best as possible. Please keep in mind, though, that the court may not be able to answer all questions. Now, you will have with you in the jury room the following form of verdict. When you have reached the verdict, you will complete the form in the way which corresponds to your decision, and you will then sign the verdict in ink. So here is the verdict form that you're going to have. This is what you record your decisions on. As you see, count 1 on the first page, failure to comply with order or signal of a police officer. And it reads, we the jury, being duly impaneled and sworn, find the defendant, Christian McLean. Then you see an asterisk symbol followed by a blank line. And then the words, a failure to comply with an order or signal of a police officer. Below that are the directions for the asterisk symbol. And it reads, insert in ink either the word guilty or the 2 words not guilty. So depending on how all 12 of you reach the decision regarding count 1, you'll place either the word guilty or the words not guilty in the blank line. So it will read, we the jury, being duly impaneled and sworn, find the defendant, Christian McLean, either guilty or not guilty of failure to comply with an order or signal of a police officer. There's then a line that says, preceded by the word dated. You'll place the date that it is that you reached the decision on count 1. You then see 12 lines below that. Those are the signature lines for each juror to place his or her respective signature. Now, Mr. Case, you're juror number 1. We go along the back row to Mr. Ader, you're juror number 6. Start back up in the front with Miss Little, you're juror 7. We go along the bottom row to Miss Ruprecht, who's juror number 12. So if you want to make a mental note of your number, that will be the line that you'll be placing all your signatures on for each decision that you reach. Below the signature lines, there's then further directions. It reads, if your verdict is guilty of failure to comply with an order or signal of a police officer as charged in count 1, you will separately decide whether the state has proved beyond a reasonable doubt that the defendant's operation of the motor vehicle causes substantial risk of serious physical harm to persons or property. If your verdict is not guilty, you will not decide this issue. You then have the next page, the additional finding as to count 1. Again, you only fill this out if you find the defendant guilty of count 1. And it reads, we, the jury, find beyond a reasonable doubt that the defendant's operation of the motor vehicle. You then see 2 asterisk symbols followed by a blank line. Then the words cause a substantial risk of serious physical harm to persons or property. The directions for the asterisk symbols read, insert in ink either the word did or the 2 words did not. So whatever all 12 of you agree in regards to this additional finding, you'll insert the appropriate answer, did or did not. You then have a space for the date, and then signature lines for each of you to place your signature. Count 2, obstructing official business. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean. You'll insert either the word guilty or the 2 words not guilty in the blank line of obstructing official business, depending on how all 12 of you decide this particular count. Then space for the date that you reach that decision. Then you place your signature on the appropriate line. The directions for count 2 read, if your verdict is guilty of obstructing official business as charged in count 2, you will separately decide whether the state has proved beyond a reasonable doubt that this violation created a risk of physical harm to any person. If your verdict is not guilty, you will not decide this issue. Next page, you then have the additional finding as to count 2, which you should only address again if the defendant is found guilty of count 2. And it reads, we, the jury, find beyond a reasonable doubt that this violation. You then have the 2 asterisk symbols followed by a blank line where you're instructed to insert either the word did or 2 words did not create a risk of physical harm to any person. Place the date and your signature on the appropriate line. Count 3, operating a vehicle under the influence of alcohol, or drug abuse, or a combination of them. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean. You'll insert either the word guilty or the two words not guilty, depending on the decision that all 12 of you reach regarding count 3. So it's guilty or not guilty of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. Insert the date and your signature on the appropriate line. The last count is count 4, it's operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. And this is similar to count 3. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean, guilty or not guilty, depending on the decision all 12 of you reach on this count. Put that in the blank line, of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. Place the date that you reach that decision, and you place your signature on the appropriate line. So let's go back and finish up the instructions. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in the light of and in harmony with all the instructions. The court will place in your possession the verdict form as well as the exhibits that were admitted into evidence during the trial. You will also be provided with multiple copies of these instructions. You will not be given anything else. During your deliberations, the court reporter will not be permitted to read back any of the testimony which you heard during the trial. You may not discuss or consider the subject of punishment. Your duty is confined to deciding whether the defendant is guilty or not guilty of the charged offense. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon this court. You must also not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel their case was fairly and impartially tried. You're also ordered that you may not take in any electronic devices or books of reference into the jury room and should cover such items as cell phones, Apple Watches, computers, law books, etc. If during the trial the court said or did anything you consider an indication of the court's view on the facts, or if you have the impression the court has indicated how any disputed facts should be decided, you must put aside such an impression. Nothing said in these instructions or in the verdict form is meant to suggest or convey in any manner any intimation of what verdict I think you should find. That decision must be made by you based solely upon the facts presented to you in this courtroom. You're also warned not to discuss your verdict or the status of your deliberations with anyone except for your fellow jurors while you are deliberating until the verdict has been returned to the court. This order must be strictly obeyed. After your verdict is returned and announced in open court, you may discuss the case with anyone, though you're not required to do so. Whether you discuss this case with counsel or anyone else after you are discharged is a matter of your own free will. Now, my preliminary instructions to you, if I said anything that conflicts with these final instructions are what are controlling for your deliberations and are binding on you regardless of what I said in my preliminary instructions. So one thing I want to touch upon, when you're deliberating, all 12 of you have to be present. If you take a break, if someone steps out to use the restroom, you got to stop deliberating. You can only deliberate when all 12 of you are present. So if you're deliberating, you take a break, and some of you stay in the room, or a couple of you guys go out to lunch together, whatever the case may be, you're not allowed to talk about the case even though it's been submitted to you for deliberations. You can only deliberate with all 12 of you present at that time. Now, jurors who are selected as our alternates are not permitted to participate in the jury's deliberations unless one or more of the regular jurors are unable to complete their service due to illness or some other misfortune. We're pleased that nothing like that has happened in this particular case. So fortunately, it does not appear that it will be necessary for our alternate to render any further service in this case. Now, Ms. Wintersteller, you were selected as our alternate, and it will not be necessary for you to serve any further in this case. When the jury convenes into the jury room here in just a moment, you'll go with them, gather your belongings, take your badge off, leave it on the table, and then you will be free to leave at that point. Now, even though you're not required to render any further service, I do need to still restrict you from commenting on the case or discussing the case with anyone or revealing to anyone how you would have voted had you been one of the voting members. When the verdict has been returned and announced in open court, at that point you're released from that restriction. You can talk about the case with whomever you please, whatever you want about it, though you don't have to. That's a decision for you to make for yourself. But at this point, I do want to thank you very much for the valuable service you provided for us as our alternate. So thank you. I appreciate that. All right. Ms. Linden, on behalf of the state, is there anything else you care to discuss further?
No, Your Honor, thank you.
Mr. Langmack for the defense? Do any of the jurors have any questions? Now, I'm not talking substantive questions, but procedurally or what's going to happen now as you go into the jury room. I suggest you select your foreperson and then decide if you want to break for lunch, take lunch, or what you want to do. Going forward, you're going to decide your schedule. We're not going to come in and say it's lunchtime or it's time to take a break and here's how long your break is. You're going to be deciding that. So if you decide you want to take lunch now, which is probably a good idea, it's lunch hour, but that's up to you guys to decide that, and you can decide how long if you want to decide that as well. The only thing I ask is that if you do take a break, whether it's lunch or whether it's just even a 10-minute break to use the restroom or get some fresh air, before you take the break, buzz Stan, let them come in there, tell them what you're going to do. Just don't go out into the hallway. I've had juries that are just wandering around and we didn't even know. We thought they were in deliberating and we didn't know that. So we can't have that. So please just let us know that for sure. But any questions at this point? All right. Well, then at this time, I do want to thank each of you for the service that you have provided and that you're going to continue to be providing as jurors in this case. By providing this service, you have certainly contributed to, again, what I think is the best system of justice that we have here in this country. At this point, you're going to retire to the jury room. The first thing you should do, again, is select your foreperson. Then you're to begin your deliberations upon your verdict. When all 12 of you have reached a verdict as to each count and any additional findings that you may be required to make, you will signal the court by the buzzer system. Stan will tell you exactly what to do for that. You will then be returned to the courtroom where your verdict will then be announced in open court. Ladies and gentlemen, you reported that you have reached the verdict. Is that correct?
Yes.
If the foreperson could please hand the verdict form to the bailiff. All right, in the matter captioned State of Ohio versus Christian McLean, count 1, failure to comply with order or signal of a police officer. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean, guilty of failure to comply with an order or signal of a police officer, dated with today's date, April 15th, 2026, and signed by all 12 jurors. The jurors were directed to address the additional finding if their decision was guilty of count 1, and they did address the additional finding. And it reads, we, the jury, find beyond a reasonable doubt that the defendant's operation of the motor vehicle did cause a substantial risk of serious physical harm to persons or property. Dated today's date, April 15th, 2026, signed by all 12 jurors. Count 2, obstructing official business. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean, guilty of obstructing official business. Dated today's date, 4/15/26, signed by all 12 jurors. The jurors are directed to address the additional finding if their verdict was guilty to count 2. Which they did, and it reads, we, the jury, find beyond a reasonable doubt that this violation did create a risk of physical harm to any person, dated today's date, signed by all 12 jurors. Count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean, guilty of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, dated with today's date, signed by all 12 jurors. Count 4, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. We, the jury, being duly impaneled and sworn, find the defendant, Christian McLean, guilty of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's dated today's date, April 15th, 2026, signed by all 12 jurors. Does either side wish to have the jury polled? Mr. Langmack? Ms. Linden? All right, ladies and gentlemen, that concludes your service for this case. Again, I want to thank you very much for the service that you provided. At this point, you are released from the restrictions that I've had on you over the last couple of days. You're free to talk about this case with anyone you like and whatever you want about it, though you don't have to. It's a decision for each of you to make. Though the lawyers often like talking to jurors after trials, find out what it is they liked or didn't like about how the case was presented. I like talking with jurors afterward, find out how we could improve the way we do our work, and I can answer any questions that you may have had throughout the last couple of days. So in fact, if you file in the jury room, I'm going to pop in there in just 1 minute. We can chat briefly, then you'll be on your way. So if you want to go in the jury room, I'll be right in there.
All rise for the jury.
Everyone may be seated. At this time, the defendant has been found guilty of the charges in the indictment. I'm going to order a pre-sentence report and investigation, drug and alcohol evaluation, and the defendant's bond will remain revoked. Is there anything else for the record at this time, Ms. Linden? Mr. Langmack?
All right.